the child's birthday was approaching, my lord, that matter regarding interim visitation, right, my lord, 1 day a month, my lord, in the in court. My lord was pleased to keep it today because the child's birthday is approaching on this Sunday, my lord, 23rd. My lord, this is appearing as item number 133, my lord.
Oh, 133 of the supplementary list.
My lord, today's list, my lord.
Who is appearing for the other side?
My lord, we have duly served, my lord. My lord has.
Who has, unless you inform that it cannot be taken up out of
We
start.
can, my lord, no advocate is appearing, my lord. We can immediately.
Then it's difficult.
My lord, my lord, whatever once, my lord was.
Sir, what can be done if you have served? Other side may not know if I upgrade.
My lord, we will immediately communicate by way
Not
of
immediately. Prior to that, without hearing them, how can I pass an order?
My lord, if the birthday is approaching
Maybe.
Sunday, my lord. My lord, if my lord sees the order, my lord, for once, my lord.
Sir, unless you, it has to be called on serially.
Lord,
unless you intimate, if it happens to you, you have been briefed from the opposite party and the petitioner upgrades and moves the matter.
My lord, the father cannot, my lord, fix it.
Unless you notify the other side, it cannot be taken.
My lord, under extreme urgency.
Son, my lord, on the birthday, my lord.
Maybe.
My lord, under extreme urgency, I'm mentioning item number 165, my lord, of today's list. My lord, it is already under the heading, my lord, upgraded matters. My lord, upon notice, I'm mentioning.
Extremely urgent, you cannot wait for one day.
My lord, section 151 has been rejected. My lord, the next date has been fixed.
Please mention on Monday.
Number 180 minute of the day's list.
Yes, what is the extreme urgency?
Urgency, my lord, execution is absolutely stalled, my lord. There is a correction, my lord.
Yes, please mention on Monday.
Yes, may I have a lordship's kind leave to me.
Extreme urgency, one matter I am mentioning before your lordship.
You cannot wait for one day. Is it that urgent?
My lord, the matter is fixed on 26th.
Maybe.
May I have a lordship's kind leave? I want to move this application on Monday. But the urgency is that I have a sanction plan. The special officer building has held that I do not have a sanction plan.
All right. Leave to file. Yes,
on Monday.
Monday. One to judgment.
For this.
One to judgment. কত ডাকলেন 1 and 2
063 of 2022. The item number 2.
Item number 1 for the state led by Miss Rashmi Ghosh.
Application for restoration.
Yes.
And recalling of the order dated 12th August 2025. The order is that.
What is the number of the application? Can 9.
Can 9.
Yes, what do you say with regard to the restoration?
My lord, the administrative department facing lots of problem for seasonal problem for enter into the Boxer Tiger Reserve Forest for ascertaining the
restoration application, madam. What?
Yes.
I'm allowing that. Ashun, can 9.
Tribunal, my lord, in spite of my application, did not entertain my application, order has been passed against me. And my lord, I have also.
There shall be an order of stay of operation of the order. Yes.
The
Next.
order, 18 September, the matter is.
Yes. Next. Yes.
Very next. Well, it is my applicable extension of interim order. Well, I have sought upon the part of this is an applicable service. Time was extended, time to try. No, no.
Have you notified the other side?
Yes, my lord, I have served.
When have you served?
I have served it, my lord. The learned advocate who appeared here, he is not sitting in the bar. Therefore, we could not find out his address. I said,
Yes, received.
I do not know, my lord. That has track report I have known.
Then
And in that
not
report, my
today.
lord, on Monday, my lord.
Not yes. Not
On Monday.
next. File the affidavit of service with the track report. File the affidavit of service with the track report.
As you know.
Yes, call the next matter.
Item number 2, my lord. Daily list though.
No, item number 2 was the correction.
Yes, my lord. I am for the 2, my lord.
কোনটা? Correction এর তো এটা। No, he said extension, that is what is the correction?
Fifth line from bottom, my lord.
What was your item?
Item number 2, my lord.
Original side নয়, affiliate side হচ্ছে।
Appellate side, my lord. serial number is 940.
940 is item number 3, not 2.
Sorry.
That is why, yes.
From bottom, fifth line, minor correction. My lord, title number 217-2021, pending before the learned civil judge, senior division, that will be my lord, junior division one.
Title suit number is correct.
Only junior division.
Junior division. Please kindly come to a cost title. What have you written?
Paragraph 6, I have mentioned and also.
The cost title you have wrongly mentioned. You have mentioned senior division. So whose fault it is?
Page 56, I have also annexed my lord, only junior division my lord. Kindly.
On the prayer of the
execution filed. Thereafter, a miscase has been filed by my learned senior friend over here's client. Now they are saying that they have independent title over here. They got the title from someone who is already
That I cannot decide now.
that is there. That is
Issue
my lord. Now what is the problem?
Is only with regard to the
The
impugned
stay that
order.
has come in between the execution.
Yes,
right?
but the issue, what was the impugned order?
The impugned order was that they wanted to get in the examination of a document which was already a part of the degree, which was already adjudicated.
Lordship keeps
By-
it for a hearing on any date Lordship chooses.
My lord, I'm suffering tremendously over here. The only thing is that, my lord, over here there was glitch. I humbly accept that there was faults on
So
my part that I could not
that deed
appear.
was already marked as an exhibit in the suit.
Yes,
Please show me that. Then why it was rejected? It should have been accepted.
my lord, that is that order also that says that it is already there. It is there in the impugned order itself.
Please show me.
Lordship keeps it on any day.
Let me see, Mr. Mukherjee. Yes, yes.
My lord, the impugned order of 15th February 2025.
Yes, yes.
There were, if I remember correctly, there were 3 orders, 3 applications, and we are here challenging 2 of them. We wanted
It's only the certified copy of a deed.
certified
That
copy
is
of the
it.
deed.
Please show me that it was already marked as an
And
exhibit.
secondly,
What is
we
the exhibit number?
wanted to bring the partition suit.
Only it was admitted only on one ground, Mr. Mukherjee. That was the only ground for which it was admitted. Let me see.
My lord,
Lordship
unfortunately,
keeps it on
no, no.
Monday. I will come with all my.
That was annexure A.
Not annexure A, exhibit A.
My lord, one second.
Annexure is a different
That
thing.
Kovala was 1967.
Yes.
1967. That Kovala was tendered by them in the suit itself, in the suit and the suit thereafter. During the suit,
It
Ayub
was
Ali,
marked as an exhibit in
it
the
was
suit.
marked as an exhibit.
Please show me what is the exhibit. Please show me that.
Lordship keeps it on Monday.
My
I'll be
lord,
able to
my lord,
assist
even
Lordship better.
I do not have the file with me right now. My lord, keeps it on Monday. Kindly,
Monday.
I will just take 5 minutes of my eyelids time.
Monday. Yes. Call the next matter.
আরে, Monday করে দেবার একটু কথা চলবে।
Not today করে রাখুন তাহলেই হবে. Yes, next.
My lord, only one request. My lord, on top of the list, my lord, on Monday's list, please, my
Yes, yes. Call the list.
Number 5.
deeply obliged.
Yes.
Hello, the interim order as granted in this proceeding was lastly extended on 22nd of July, which is going to expire by the end of this month. Now, the subject matter of challenge in this original application.
Yes, you are appealing for the opposite party.
1, 2, 3.
The interim order is.
Grateful, man.
Now, in this matter, I am for the petitioner, my lord.
Same thing.
No, my lord, the other matter, my lord.
Other matter.
Other matter. My lord, the interim order was lastly extended on 22nd of July, my lord, and is going to expire on
All it same order. Next. This matter is also appearing in the list.
appearing in the list. My lord, I am
Yes.
for the petitioner, my lord.
I'm for the opposite party, my
My
lord.
lord, this matter has also appeared on 22nd of July, my lord, and the interim order is going to expire on 30th of August.
Same order. Next.
My lord, may I press one thing, my lord? I am suffering this order, my lord. The only point is that the written objection was filed after expiration of 10 days in terms of the direction passed by the Honorable Division Bench. That is the only point in this matter. And that is why, my lord, I am suffering. Suit has got stalled.
Written statement filed after 10 days.
Written objection.
There was a direction
I filed
Right.
written
An objection to what?
to the
the injunction
Now,
application.
there was a
That-
division bench judgment, my lord, which has directed my learned friend's client to file a written objection to the injunction application within prescribed period, my lord. Now, that was not followed. We have taken out an application for forfeiting their right to file their written objection, or that application was rejected. The point of issue, my lord, before your lordship, is whether the time period fixed by the honorable division bench. But that
You
is
have to
the issue.
satisfy if the time period is fixed by the division bench,
That cannot be
it cannot be extended
My lord,
either by the trial court or by me. Sitting singly. You have to take
my
other
lord,
requests.
may I?
Yes, yes, please.
My only point is that I'll satisfy your lordship. This short point, I'll satisfy why I could not file that.
I cannot go into that.
I
The
appreciate,
legal issue is, if the division bench has fixed the time limit,
my lord.
can that be bypassed? The trial court also cannot sit in
place my case before the learned trial court without my objection, because my lord, I'm suffering the interim order. The suit should go on, my lord. That is what my.
Yes, Dinto?
Yes,
May I please?
Then you are not aggrieved.
That written objection will not be taken on.
That is submitting.
Yes, my lord. Otherwise, my lord, the entire suit is being stalled, my lord.
Or you can do one thing, you can avail of the other recourses. That also you can do. Choice is yours.
I leave it to your lordship.
So I'm giving you liberty to take appropriate steps.
My lord, this is the only point, my lord.
No, the written statement was not filed within 30 days, my lord. Though
No, my lord, it was filed.
No, my lord, it was not filed, my lord. The summon was.
I'm not on the written statement. This is only on the written
Written
objection.
objection, my lord.
What is the order dated?
My lord, the order impugned is, my lord, 18th August 2025. If my lord will see, may I place the judgment of the Honorable Division Bench, my lord, the relevant paragraph.
কিচ্ছু লাগবে আমি ইনজাংশন এমনি সাফার করছি, আমি করে নেবো সুট আদারওয়াইজ আটকে পড়ে রয়েছে।
Yes, give me only one judgment,
My lord, may I hand over?
which according to you is the best
My lord, may I
on
hand-
that point.
Para 12, my lord. Please.
You went to Himachal Pradesh.
But there are other judgments also, my lord. There are of our High Court.
Could not find any judgment of
Yes,
our court.
Yes, my lord. I've got that, my lord.
Give that. Why have you traveled that far?
Yes, my lord. My lord, may I hand over? Para 4, my lord. Para 4. Para 4. There is also Supreme Court judgment, my lord. But what happened in this case? There was a time period fixed for deposit of cost. That time period was elapsed, my lord, and that time period was suo motu increased by the district judge. Para 4.
Once you travel to Himachal Pradesh, then you have gone back to 1933,
My lord, may I-
and this amendment was made in 1976, 67. Calcutta amendment.
Para-
Where is the Supreme Court judgment?
my lord. Para 16, my lord. Para 16. This is also Supreme Court, my lord. Para 6. 16.
Painful exercise.
My lord, the analogy, my lord. Para 16, my lord. Analogy.
Sir, there are direct decisions on 148. Please search out, come on Monday,
Para 6,
not today. There are direct decisions of our court on 148.
my lord.
Yes,
May I
not
take it?
today.
I-
Yes, next.
Great one.
My lord, I am for the petitioner. This
Yes.
matter has come up only for expeditious hearing.
You are for the petitioner.
Yeah, I am for the petitioner.
Yes, expeditious hearing of what?
Expeditious hearing of my title appeal 61 of 2014.
What is the stage of the appeal?
It is in the argument stage and almost 7 to 8
14th
occasions.
of August, what happened?
14th of August, last occasion. My lord, it is agitated in the petition that since 2000, since order
The
number
written
20
notes are only directed to be filed on 14th of August. Did you file the written notes?
for me, I have already submitted. For the
Uh,
respondent, they have not.
What is the next date fixed?
Next date fixed.
This application under Article 2. None appears for the petitioner at the time Aviator husband, yes. Yes.
I am the wife respondent in a suit, my lord, under section 13 of the Hindu Marriage Act. Now, my lord, my application for enhancement of the alimony pendant light has been rejected, my lord. Kindly, my lord, comes to page
Your
18.
enhancement.
Enhancement.
What was the original
Page
alimony?
18, page 18, my lord.
What was the amount of original alimony?
6,000.
6,000.
6,000.
It has been enhanced to
Rejected.
entirely
prayed for-
rejected.
I prayed for enhancement up to 15,000.
Yes.
Page 20, kindly, my lord, comes.
22.
Page 20.
20.
20, my lord.
Yes.
And you sees the ordering portion. Petitioner is entitled to maintenance pendant light at the rate of rupees 6,000 per month from the date of filing of the case. That is from 5th of October 2015. Petitioner is also entitled to get cost of litigation amounting to rupees 10,000. OP is directed to pay maintenance allowance to the petitioner within 7th day of every succeeding month, and he shall go on paying further amount of rupees 1,000 per month along with the current maintenance to clear the area of maintenance already became due by this time. Now, my lord, kindly, my lord, comes to page 21. This is my application for enhancement. Para 4, my lord, I have given the breakup, my lord.
When have you filed this application?
I filed this application, my lord, on 10th of February 2021.
10th of February 2021.
2021.
In 18, this order was passed.
In 18, this order
In
was passed.
2021, you have filed this.
Yes, my lord. Thereafter, my lord, their objection is at page 24.
And it has been disposed of on
9th
July
July.
by the impugned order.
9th July 2026.
what is the stage of the matrimonial suit?
Next date has been fixed for my lord DW.
DW means you.
Me.
What is the next date fixed for DW?
5th of August it was fixed, my lord. Thereafter, my lord, I to take instruction when is the next.
I'm directing the evidence of the defendant to be concluded within
No, my
4
lord, kindly,
weeks.
my lord, sees how the court has dealt with it. No, my lord, kindly, my lord, sees. This cannot be done, my lord. Kindly, my lord, sees. Kindly, my lord, takes up their objection, my lord.
Do you have the entire order sheet?
Order sheet, my lord.
Please show me the entire order sheet. Let me see. What was your conduct during the pendency of the suit? Please produce
Lord,
the order sheets
I have a
from
annex.
2018 till 2026. This alimony will go on. Please produce the order sheets.
Yes,
You have the order
kindly, my lord,
sheet.
comes to page 41.
Yes.
41, my lord, kindly, my lord, sees.
My lord,
I have annexed, my lord. 6th of March 2026 order, my lord, kindly, my lord, sees.
Oh, you have annexed the entire order sheet?
No, not entire order sheet, my lord.
Yes. Why not entire order sheet? Let me see what was your conduct during the pendency of the suit.
my lord, the
No, they
conduct.
also need to, your lordship needs to seize their conduct also.
My lord, the
Kindly, my lord, sees my page 45, my lord, my statement of, my lord, area dues. My lord, what they
What
have
is the
not
area
paid.
due?
My lord, kindly, my lord, comes to page 45. Page 45, my lord, I have given the statement.
কোথায় সেই অর্ডারটা দাও কিছুই অর্ডার আনি
60,000.
No, see, yes, 60,000 up till July. Up till July, 60,000.
Up
Kindly,
to,
my lord, sees
up
court
till
record.
July of 2026.
2026, 60,000.
Yes.
Court has
Have you
also.
paid this area amount?
my lord 20,000 is the area.
No, my lord, how the court has dealt with that, kindly,
And my lord,
sees.
the conduct of the wife, if your lordship kindly comes to the internal page 3 of the impugned order.
Internal page 3.
Yes, my lord. My lord, she has ousted the entire family members. The husband, my lord, the husband,
Is to be dealt in the suit,
my lord,
not
the
here.
husband,
Not here.
the husband, the father-in-law, the mother-in-law, the brother-in-law, their child, everyone has been ousted. She has been occupying this 2-storied house herself alone. My lord, it consists of this much of this many bedrooms and the living room. She has given on rent to these rooms
Yes,
to
nothing-
other tenants.
Nothing so.
My lord, she is
Nothing so.
earning from such tenancy. My lord, this has been considered by the learned court, jurisdictional court, and which is why her prayer for
Nothing
enhancement has
so.
been
Kindly, my lord, sees their
refused.
affidavit. Page 34.
Mr.
My lord,
Mr.
they had
Mondo,
not
don't get
even produced
agitated.
the
Don't
salary
get,
slip.
don't get agitated.
No, my lord.
Who are in occupation of that 2-storied
Yes,
building?
I am in occupation.
You
Well,
alone?
I have a right under the Prevention of Domestic Violence Act, my lord, of shared household.
You alone is occupying. Or
Yes,
there
my
are
lord,
some other relatives, some other
No,
persons.
I am alone.
I'm sending an officer of the court just now. Let him go and find out.
Before that, my kindly sees me not their conduct, but what they had stated on affidavit, page 35, page
Is it
34.
a fact that you have ousted everyone from that property?
That is to be
Please
decided
take,
in this.
please take instructions
Yes,
and
my
come
lord.
back.
My
That is
lord,
to
we
be
are,
decided
we
on
are
this.
residing in a
That is-
rented house now.
That is an allegation against me. That
I'm
is to
asking
be
you that
decided on
What
trial.
is your instruction?
My instruction is that I am alone residing.
All right, 2 p.m. Please take instructions and come back. 2 p.m.
But your lordship will kindly, Milord, go into this aspect, Milord.
Why?
In my enhancement application.
Why?
In my enhancement application.
You will oust everybody.
Milord, they are kindly, Milord, says this is an allegation against me.
All
But
right.
that has to
How
be
many rooms you want
that
of that 2-story building? I will direct them to enter that property.
But till that they had not taken any step. This suit is
No,
kindly.
no, Mr.
20.
Mondal, do you have any objection if they enter into that property?
No, Milord, I have no objection.
Please take
2015.
instructions. That is what I am asking you. Please take instructions. If you have any objection for them to reside in that house. This is a 2-story building. How many rooms are there in the ground floor? How many rooms are there in the first floor?
Well, 2 bedrooms, 1 small bedroom, drawing cum dining, room of staircase, 2 washroom, kitchen.
Where is that? Where is that?
My lord, internal page 3 of the impugned order. In block letters, my lord.
Where are you residing? Ground floor or first floor?
They are not residing. I am in
No,
entire
no. I am asking you. You are residing where?
I am in entire occupation, Milord.
But there are tenants.
You require the 2-story building.
But I am entitled to get shared household. But if they provide me rented accommodation, I have no.
No, you stay
No,
there.
I have no problem. If they provide me rented accommodation,
I'm
I
not
have no
asking you to go out. How much portion of that property you want? Shared household means you have to share along with others.
Yes.
Yes.
But 2015, they are not coming.
Yes. So,
2015, they are not coming.
since you have come now, they are coming
No,
now.
Milord, if they say, Milord, what steps they have taken? From 2015, no steps taken. From 2015, no steps taken. And
It shows
if it
that
bit of
it shows, Mr. Bondol, the more you are vociferous in this argument, it shows your conduct.
No, Milord, their conduct
That is
also.
what I am asking you. Can you allow them to?
Yes.
Don't say on that. Please take instructions and then.
I will take it. Before that,
So I'm coming at. Please come at.
No,
2
Milord,
PM.
kindly, Milord, comes to their affidavit, Milord. What they have stated.
I will come to that. I will hear that matter on merits at 2 p.m. Please take entire instructions, whether you are in occupation of the entire 2-story building, whether you are agreeable to allow them to enter into the property. Then I think many of the problems can be solved.
Lordship will allow this from this application, Milord. This is my enhancement application which has been rejected.
Can you not come back with the instructions? This shows, Mr. Bondal, there is something.
She is earning from the tenancy, my lord.
There is something. The more you will object to that, it means that there is something. 2-story building will oust everyone and you will say yes. 2 p.m.
I'm grateful.
Yes. Yes, Mr. Mondol. Item number 11. Oh.
Milord, the person responsible, Milord, alleged person responsible, Milord, under section 218 proceeding, Milord, is the petitioner before your lordship. Milord, if your lordship, Milord, pursuant to the order of the Honorable Division Bench, ultimately the person who lodged the complaint, Milord, the direction was passed that authority should take a call whether, Milord, the allegation of unauthorized construction is correct or incorrect. Milord, I shown before the authority, Milord, 218 proceedings started. I shown before the authority that under the Pradhan Mantri Awas Yojana, this construction is being raised. Admittedly, I could able to produce that, yes, it has been
You
done.
have the scheme under the Pradhan Mantri Awas Yojana.
Milord, the scheme, Milord, I have annexed.
Yes, then what happened?
Yes, the admitted case is that the 218 proceeding, the court suggested that yes, initially 400 and something was the Milord permissible area within which this type of construction should be done. 400 was the permissible limit within which this type of construction should have been done. Subsequently, by an agenda of the UD department, from 400, this has been enhanced up to 700.
So 700
Yes.
construction can be.
Survey was done. My construction is within not 500. It's 450 something. Within
Below
500.
700.
Below 700. This 700 was done sometime in 2018. My construction, my payment.
So your construction was done in 2018.
No, this amendment of Milord enhancement was done in 2018.
And your construction on?
Admittedly, Milord, the check, Milord, the amount has been remitted. Your Lordship knows until and unless the amount is being remitted, the phase-wise construction cannot be started. So amount has been remitted sometime in 2021, 2022. The court said,
After the amendment.
naturally, Milord, the court said the rule is not retrospective. I did not pray for it. It has to be retrospective. It is prospective. So, Milord, wherefrom, Milord, my construction can be said to be unauthorized. Your Lordship will not find, Milord, any reasoning from the order. Kindly takes up now the order of 200.
You have a sanction plan.
Sanction plan, your Lordship knows this is a model sanction. This type of construction, separate sanction is not necessary.
Where is the scheme? Where does it say that separate sanction is not necessary?
Milord, kindly takes up this. This is the bunch of document.
No, do you have the scheme? It says it can be done without any sanction.
It is containing, Milord, a model sanction. This is the, Milord, I cannot go out from whatever is there, Milord, in the model sanction. It's for all.
No. Then any person can.
That's the scheme, Milord.
There's no
Because
necessity
it's a
to.
departure from the entire, Milord, the rule of the West Bengal Municipal Act. But I shall show that provision also. There is a complete departure. Rule 56 is starting, Milord, notwithstanding anything contained elsewhere in the rules. Rule 31 obliged me, Milord, to make any construction prior to, Milord, the construction is to start to obtain a sanctioned building plan. Rule 56 is a departure. Like, Milord, Rule 19 of the West Bengal.
In case of buildings constructed by governments or any of the statutory bodies under any government approved scheme, it's not personal.
That's why, Milord, the model sanction.
No, this says 56 is. This exemption is only with regard to if the construction is made by the government or statutory bodies, not by the private individuals.
That's why, Milord, the model sanction. The model sanction, and this is not also, Milord, the case of the, Milord, municipal authority that it's requires sanction. The case of the municipal authority is that my area, constructed area, is 452.
Please show me the order of demolition.
Yes.
Initial.
Milord, if your Lordship takes up, Milord, page, yes, it starts with from page 18.
18.
Now, Milord, kindly takes up the relevant portion, that is point numbers 18 and 19.
18 and 19.
Yes, Milord, at page 26 of my Lord's brief. Internal page 7 of the order.
Oh, 26. I'm looking at page 18 and 19.
Point number 18 and 19. Where, Milord, this, Milord.
This is the order passed by the Board of Councillors.
Board of Councillors. No, Board of Councillors.
No. This is the finding. She has got no sanction plan from the competent authority, though it is compulsory. Municipal authority also says sanction plan is compulsory.
That is, Milord, totally departing, Milord, the rules. My sanction plan I have annexed.
You said that it's also not the case of the municipality. The sanction plan is not necessary.
No, they have stated, Milord, kindly see
the finding of the municipality.
Why it is, Milord, because it's covering the area of 450
Not only
to
that, there are two
501.
aspects, Mr. Mukherjee. One is no sanction plan, though it is compulsory. That's the finding.
My sanction plan, Lord, it's the model sanction plan that has been given along with the scheme itself. Otherwise, Lord, this will be nugatory. I have
Please
handed
show
over
me
to
that
your lordship.
how you have that submission you have made before the appellate authority, that sanction
Nothing-
plan is not necessary.
in my
Please show me
grounds,
that you have
in my
raised that
grounds.
point
Yes, I'm coming.
and how it was dealt with.
Kindly takes up page 32, ground number 4.
30.
Page 32, ground number 4. Specifically, this point is being urged. Now I will go before your
From the
lordship.
impugned order.
I'll place. But this
Grounds
point
you
was-
may take many points.
No, Lord, this point has specifically taken. Kindly takes up for that
Mr.
the same
Mukherjee,
scheme
you have to raise. You may take 20 points in
has
the
to
ground.
dealt with, Lord. It's not that, Lord, always it is in our hand, Lord.
Then
We
you
can
go there,
argue.
file a review.
For that, Lord, review is not necessary, Lord.
Why?
If I
If
argue,
you say that you have urged not
there can
recorded,
be, Lord, subject to correction, there can be, Lord, 10 points agitated in my written, Lord, whatever, Lord, the grounds. But out of that, Lord, 11th point is being, Lord, argued verbally. Then your lordship can say you
No,
have
no,
not
no.
taken a grounds. It is something which has only
if in the memorandum of appeal or anything, you have raised 20 grounds,
Correct.
but you have only pressed at the time of argument only 2 grounds.
then the landed judge has to record that I am not pressing the other ground. Otherwise, Milord, this cannot be.
It's deemed that you have
For-
not pressed.
For that, Milord, then Milord, the
So that,
clients will be nowhere. We will be, Milord, entirely up in the hand of the judge.
That's
Because
the Mr.
this cannot
Mukherjee,
be, Milord,
because
the landed judge can always say
you
that
may
there
feel before
no, Milord,
one
that can
forum
happen.
that 1 point will be
But
sufficient.
once I have
Now it's decided on the other, on one way, you go before another forum and say, no, I have
taken
raised
that
all
ground.
20 points, only one has been dealt
There
with.
can be a situation, Milord, the landed judge is writing that no, in spite of taking several grounds,
Then I
he
have
has
to,
taken.
in this matter, I have to record these are the grounds, each and every grounds I have to deal with. Though it has not been argued, this is the
Milord, in
of
the
the
other
game.
way round also, Milord, the litigant cannot suffer for that, Milord. Kindly takes up, Milord, I have shown before your lordship paragraph, Milord, ground number 4. Now takes up, Milord, the judgment.
Yes.
Milord, your lordship has taken, Milord, this judgment, Milord, for quite a long time, because the other matter also, this learned judge used to say, once you have been given notice, there is no violation of the audio alteram partem, so this court will not interfere with anything. Notice, hearing given, 200 proceeding, elaborate judgment. So kindly takes up, Milord, it's a longish order. Every grounds, everything has been, Milord, page, my lord would find, Milord, page 6, internal page 6. The entire grounds of appeal is being set out by the learned judge. Thereafter, point for consideration. Page 10. Page 10 কোথায়? হ্যাঁ, decision with reason টা তো বললেন আপনি। Provision is being quoted, Milord, kindly. Now takes up, Milord, internal page 16. Point number 24 onwards. This is the observation of the learned judge. Because prior to that, Milord, is the
That
submission.
paid for regularization.
That's, Milord, for abundant precaution my client have.
Where is the application for regularization?
No application, it's for submission before the.
Where it was recorded?
Yes. Oral.
Why did you pray for regularization, Mr. Mukherjee? If you are within the scheme, sanction not required, so everything is legal, you will then again pray for regularization.
That's for abundant precaution, Milord. It's not that my legal right. I have
show me-
also pleaded.
Please show me where it is recorded that you have prayed for regularization.
Page 27,
Yes.
point number B.
Point number B,
B. Because why, Milord?
the oral prayer.
I have shown before your lordship in other matter, Milord, Milord, rule 32 is being amended subsequently.
Rule
32. 32 is being amended subsequently. ওটা কি ওখানে আছে? ওখানে নেই। Amended in 2023, inserting, Milord, a proviso wherein, Milord, the power of regularization which was not there prior to 2023, that was, Milord, incorporated. For
And
that abundant precaution,
this
Milord,
is this was incorporated when
2023, Milord,
2023.
I'm not on that right now, my lord. That will
Yes.
be my secondary. Now, my lord, kindly see, my lord, the order passed.
Yes.
I may say before your lordship that paragraph, my lord, internal page 17,
Yes.
paragraph 27, or your lordship can takes up from internal page 16, para 24 onwards. That's the observation of the learned judge.
Yes.
218 interpretation is being granted. It is been given. Rule 32. So far as regards the scheme, the model plan, my submission, what will be the effect of vis-a-vis these two provision? Nothing is being answered. You know, 218 rule 32, we all know that yes, it generally it applies. But while Milord, in case of this type of scheme, when there is another provision and a model Milord building plan approved by the UD department, the model building plan Milord itself suggests
Which municipality?
it's contact.
Who appears for contact municipality?
But usually, Odhikari, Nilanjan Odhikari.
Where is he?
খুব difficult.
It's in your room.
আসেন?
Ask him to come.
But I have been told today he has not come.
Today
I'm
he has
told
not
that.
come. Yes.
Again, he will come and say, I will have to serve copies to the municipality because to now Milord, the administrator is there. So regularly matters.
Petitioner is Mr. Mukherjee, learned advocate, appealing for the If you want, Mr. Mukherjee, I can fix it on 11th, yes. Please take it back.
I'll produce my lord next.
Yes, next.
My lord, for the
Yes.
for the petition, my lord. We are challenging one order, my lord. That is
Order?
dated, my lord, 9/2/2026, my lord. Where
Yes.
the repairing order was there was a commission report, my lord. The building is in a dilapidated condition. We just wanted that to be repaired, my lord. That has been rejected by this order, my lord. We are challenging
Repairing application rejected.
yes, my lord. To that extent, my lord. Local inspection was already carried, my lord, and this is the report, my lord. My lord, is appearing over there, my lord. This application is still pending, my lord.
Which application is still pending?
39, sir.
Sir, that has been rejected. What are you saying? So that has been rejected by the impugned order.
For the reading, it says, my lord.
Have you gone through the brief?
Yes, ma'am. My lord, it goes like this, my lord. Written objection filed by the defendant number 9, my lord.
Written objection is filed by the defendant number 3 in respect of the petitioner order 13 rule 7 and petition printout of picture showing the condition. Same became hard both landed advocates at length. According to the landed advocate for the plaintiff, the condition of the scheduled property is very poor. For that, inspection by advocate commissioner is required based on the points of local investigation. And you are saying that's pending. And this has been allowed.
Oh, my lord, no. I'm correcting myself, my lord. That is, my lord, that was the report which we got, my lord. But this is rejected. Yes, my lord. My lord is right, my lord. This is rejected. Now.
Then what remains? Please show me that from here, what repairing you want? Where is your application for repairs?
This is not annexed, my lord.
Please give a copy.
My lord, we just need adjournment. In that case, my lord, we will bring that, my lord.
Sir, how could you draft this civil revision application without those two basic petitions?
If we get a pass over, my lord, we will bring by that.
After some argument, the landed
Item number 13, I beg to appear on from the petitioner, Lordship.
yes.
A tenant under the opposite party, and the opposite party had filed a suit in 2016 for non-payment of arrears rent from 2005 till 2015, and on the ground of self-use. Lordship, the same was decreed, and the same was decreed against me, and I was asked.
Eviction suit under the West Bengal Premises Tenancy Act,
Yes.
1997 or 56?
97, Lordship.
Yes.
But I preferred an appeal against the same. The appeal during the pendency of the appeal, the deposit which was being made by me before the trial court, as per the order of the learned trial court for payment of rent,
that, Lordship, upon filing of the appeal, I defaulted in payment upon filing of the appeal.
Fine.
Lordship, the area, the rent, including the area rent from 2005 till 2015 has been submitted by me. Thereafter, on regular basis, I was supposed to file the rents in favor of the before the
Appeal is the occupation charge. Where is the question of depositing rents
Yes,
at the?
the occupational charges was
Show me what was the occupation charges decided?
Lordship, the occupational Lordship, at the time of filing of the appeal, there was no such direction for paying of occupational charges. So I was required to file the rent, which was decided.
Rent, why? How will you deposit rent? Because once a decree has been passed, landlord-tenant relationship is severed. Where is the question of depositing rent in an appeal?
Lordship, that order has not been annexed with the instant application. But Lordship, admittedly, I made an application.
Give me a minute, please read.
February. My against my application.
There is a hearing of the stay application on that. You will be getting a chance to make payment of the occupation charges.
Yes, Lordship. For that, I had on
At the time of hearing of the stay application, condition will be imposed. Then he will deposit.
Then very well, Lordship. Then the Lordship may kindly clarify that same in my.
Asun.
the time maybe my application for deposit.
Stay application is there. You move your stay application. Yes.
Item number 14, my lord, I am appearing on behalf of the petitioner. I am challenging the order dated 14th of July 2026, my lord, whereby the amendment application filed on behalf of the opposite party, my lord, was allowed by the learned trial court at the stage of further arguments.
At the stage of further argument,
the
what is the amendment sought
My lord,
for?
the amendment sought for is a purported correction of the valuation of the plane,
Valuation of the suit.
the valuation of the suit.
Suit is pending before which court? Junior division, senior division?
Senior division, my lord.
Senior division.
The learned,
What was the value? What is the suit for?
My lord, the suit is for partition. Initially, at the stage of filing of the plaint, the suit was valued at rupees 50,000. My lord, subsequently, 6 years passed. Evidence was adduced. Cross-examination took place. The argument was going on. At the stage of further argument, my lord, they came up with the application for amendment, stating that the suit had allegedly been incorrectly valued and the correct valuation should be rupees 28 lakhs.
How are you prejudiced by that?
My lord,
It will also not house the jurisdiction, pecuniary jurisdiction of the civil judge senior division. That's unlimited.
Yes, my lord,
Then
that it will not. But my
there's
lord,
no question of the jurisdiction.
yes. My lord will just kindly consider the proviso to Order 6, Rule 17 once. My lord will kindly consider. Because over there, I will just take 1 minute of your lordship's time. Order 6, Rule 17.
In spite of due diligence,
In spite of due diligence.
he could not have brought the matter before the commencement of trial.
My lord is
All right,
absolutely correct.
I will record that. This application under Article 220. When have you been enrolled?
My lord, 2020.
Thank you.
Right.
Yes, next. Yes.
Madam Chairman. My lord, rejection the order 1 Rule 10-2 application, my lord. Order 1 10-2 application. My lord
Has been rejected.
rejected. My lord,
What is the suit for?
suit for my lord defamation and damages, my lord. Suit
Defamation and where is the plaint?
Then my lord, this is the my lord another my lord petition in the pending, my lord. My lord,
Plaint, give me the plaint. Give me the plaint. Yes, whom do you want to add?
My lord, add my lord, my lord, addition of my lord, page, my lord.
Page 7.
Page 7, my lord.
Whom do you want to add?
My lord, the like in course of the my lord, the evidence, my lord, the PWD disclose the everything known the my lord finance manager. My lord,
Everything?
known is the finance manager. My lord, on that day, my lord, I want to add the finance management manager and learned court below issue the witness to someone to witness. My lord, and thereafter, my lord, the order was and next date, my lord, this is what recall. And thereafter, I have challenged, my lord, this petition, my lord, the lying pending, my lord, the serial number combined is 859. And thereafter this order during the pending of the I paying for time, not time was granted. Again I have to file this application the file order 1 Rule 10-2 application file, my lord, disclosing all the things.
No, what is your allegation against that person?
My lord,
How is
allegation, my
related
lord,
in a suit for defamation?
my lord,
There is no
suit-
allegation in the plaint as against this
my
person.
lord, suit for defamation, my lord, only the false criminal case and terminate them from the service.
Yes, for that, what the finance manager will do.
My lord, the under instance of the finance manager, everything was done. My lord, this was the disclosure.
That is not your case in the plaint.
My lord,
That's not your case in the plaint.
my lord,
That is not your case in the plaint. Please show me that that is the case. At his instance, it was done.
either
You wanted to summon this person as a witness.
yes, my lord. Only my lord,
So, that is neither here nor there. So, how is the next
he
a
appeared.
witness?
He appeared.
Then-
And there is the next date, my lord, the file, my lord, the only the time was granted for the filing the Bhokaladroma and taking the time, and thereafter, my lord, recalling the planet code below, recall the order. This is
what is the item number of the other matter?
my lord,
Is there any caveat in that matter?
yes, my lord, 8.
There is a caveat in that matter.
No, man. No.
Item number
859, man.
859.
Science combined list.
ওটা বার করুন তো combined list 859. Please wait. Pass over. 859 টা বার করুন, বার করে বলুন। Next.
For the petitioners, my lord, praying for expeditious disposal of a title suit, my lord.
Title suit, what is the stage of the suit?
My lord, 18th of September is fixed for cross-examination of PW2.
What is the date fixed?
18th of September,
18th of September,
Yes.
cross-examination of
PW2.
this application under Article 220. Yes.
My lord, this is my application praying for expeditious disposal of the title suit 1542 of 2025.
Who are you?
I am the defendant, my lord.
You have filed order 7 to 11.
Yes, my lord.
This application under Article
I appear for the petition. Here, my lord, is against the order passed in section 24 application,
Yes.
filed by the wife.
Yes.
Husband filed the divorce suit. My lord, the wife filed section 24 application, my lord, for praying for maintenance of his child, of the child, which is, my lord, the page 18 is the application for, my lord,
You are the husband.
and the husband.
After all, it's for the child. It's your child.
Yes, I have, my lord, long before, that is October 2023, I have been paying voluntarily for the maintenance of the child.
What is the age of the child?
3 years. My lord,
What is the amount of alimony?
12,000.
Only
I
for
have
the
been-
son.
Only for the son. My lord, your lordship, kindly see the order.
12,000
order.
is reasonable, sir.
My lord, kindly see.
Can you say that child can be maintained less than 12,000 in a month?
I am earning 25,000. I am, my lord, engaged in a, my lord, a contractual job under the.
What is the finding with regard
My
to
lord,
your
kindly
income?
see page 2, internal page 2 of the order, impugned order. Internal page 2 of the order. First, second, third paragraph, that is the findings of the court. Both the parties have also filed affidavit of assessed liabilities. Affidavit
The
filed
learned
by the
advocate appearing for the Can I come after 5 minutes? CO2523 of yes.
Appear.
Yes, what is this pattern?
But I appear for the defendant in a eviction suit. Now, the notice to quite which was served, it was pleaded, it was served, the suit was filed in June 2019. Now, when the trial is going on, they filed an application under Section 65 of the Evidence Act. To prove that notice with the Xerox copies. We filed the objections because the pleadings which they made in their applications, first they need to prove that the notice was actually sent at their instructions. These are the requirements under Section 65 of the Evidence Act. The learned judge allowed.
Yes. So according to you, the requirements have not been satisfied.
Satisfied.
Evidence Act
just show the pleadings.
Evidence Act din to
But may I hand
nahi.
In the written statement, we denied receipt of the notice. But I'm just showing the relevant first relevant pleadings. It will not take more than 2-3 minutes. The plain starts at page 15. Kindly take
15.
15.
Yes.
Straight away come to paragraph 5 at page 19.
Yes.
This is the pleading regarding the notice.
6-4 notice is 18th of March 2019.
2019.
Yes.
Issued by one Messrs. J. Sanarwala and Company advocates. They said that the said notice was sent to the defendant by registered post with AD on 18th of March. The defendant did not receive the said notice and consequently the said notice returned undelivered with postal remark refused. Now, what is my written statement? Kindly take page 29. It starts from page 24. Paragraph 17.
Yes.
With regard to the paragraph 5 of the plain defendant's
service you have denied. Service you have denied.
Have denied exclusively.
Yes.
But inspect twice. Kindly take paragraph 18, last line.
All right. Service you have denied. Yes.
Now they file this application. Kindly see the pleadings first, Page, it starts from page 32.
32.
Yes.
What is 32?
The application under Section 65 of the Evidence Act.
Yes.
Now the suit was kindly keeping in mind, suit was filed in June 11th, June 2019. This date will be relevant.
Who is deposing? Do you have the copy of the deposition?
No, no deposition. The court allowed. It needs to be proved. That is one of my arguments. I'll be supported by a judgment of the Honorable Supreme Court.
Only on the basis of this application it has been.
It cannot be. I kindly see the pleadings also. And when these facts have been denied by the defendant in their written objection, it needs to be proved. The circumstances needs to be proved. Kindly, I'm just showing the pleadings, it starts from page 33 from paragraph 5 onwards. Paragraph 6. Sorry, may I read? The petitioner submit that they only have in their custody a copy of the notice of eviction, which was duly served upon the defendant. A copy of the notice was handed over to the plaintiffs by the learned advocate Nikita Indodia at Jet Sanaralia and Company. It's a solicitor firm. The petitioner submit Sanaralia Company through their learned advocate Prius theory filed the instant suit. The petitioner state that
Yes,
even-
which judgment you are trying to rely upon?
Yes, I'm just, may I just continue? Two paragraphs. The petitioner states that even on contacting learned advocate Prius sir, it was ascertained by the petitioner that the learned advocate such and such had handed over only the photocopies of the original to the learned advocate Prius sir. Alright, this was filed in 2019 itself. Now then, paragraph 8, they said that Ijaz Sanorawala expired during COVID-19 without giving date or any specification. And this conducting advocate was somebody else who left India and now started living in Paris. When she got married, nothing has been done. And this was their pleading. And on that basis, without any evidence, the first judgment I will be citing 2007, 5 SCC. 3 judgments I will be citing. Kindly take straight over paragraph 8 and 9 of this judgment. In fact, those judgments, during the trial, it was now essentially secondary evidence, then evidence which may be given in the absence of that better evidence which law requires to be given first. When a proper explanation of its absence is given, the definition in section 3 is exhaustive as the section declares that the secondary evidence means and includes, and then follow the 5 kinds of secondary evidence. Then 9, the rule which is the most universal, namely that the best evidence or evidence the nature of the case will admit shall be produced. Besides the objection, that rule only means that so long as the higher or superior evidence is within your possession or may be reached by you, you shall give no inferior proof in relation to it. Section 65 deals with the proof of the contents of the documents tendered in evidence. In order to enable a party to produce secondary evidence, necessary for the party to prove the existence and execution of the original.
Mr. Bandopadhyay, learned advocate, appearing for
Ghosh appearing behalf of the petitioner, my lord. He is engaged courtroom number 39, my lord. I'm praying for short passover, my lord.
expeditious hearing. What is that?
My lord.
This application
for the opposite party petitioner filed an application for OS before the learned district judge, Indian Succession Act, Section 275. The OS filed in the year of 2013. So early disposal of the OS.
You want early disposal?
Yes, 2013. Already 13 years have already passed.
You are not challenging this order, 106.
Yes, this date, my lord, on 28 September 2026. Next date is fixed.
28
September 2026. But
for
my lord, the
evidence of PW3.
No, not only that. That is the adjourned date and the PW3 evidence of the.
Yes, evidence of the PW3.
Evidence of the PW3.
This of what? This application under Article 227 of the Constitution. Yes, Mr. Manchu.
My lord, this is my application, my lord, under Section 8 of Land Reforms Act. Preemption. My lord.
Preemption application, what happened? Who are you?
My lord, I am the co-sharer.
No, are you the preemptor or preemptee?
Preemptee.
Preemptee. Preemptor. Yes, what happened?
Preemptor. My lord, I am, my lord, adjacent owner, and my lord inherited the property from our predecessors, and the person who sold this property, my lord, he also inherited. We belong to same family, and my lord, without giving any notice or anything.
No, adjoining owner, there is no provision for giving notice, Mr. Moitro.
Under
adjoining owner is not a.
Well, that's true, but I was not aware of the fact.
What happened? You have filed after the period of limitation.
My lord, that's true.
Your
Cannot be helped.
Lordship kindly see.
Section 5 does not apply.
No, your Lordship, but that's why your Lordship will kindly see knowledge from the date of knowledge, my lord. Kindly look at my lord page.
Not from the date of knowledge, Mr. Moitso. If it is adjoining owner, it's 4 months subject to correction from the date of transfer.
Transfer.
Not from the date of knowledge.
No, that's true, my lord. But we had no knowledge. It was, my lord.
Maybe.
My
It's a weak right. It has to be strictly construed. And Section 5, that's also settled because the earlier view was that Section 5 would be applicable since it is an application. Since it is an application.
Yes.
Now it has been well settled. Section 5 not applicable. It's a deemed suit. It's a deemed plaint. Section 5 will not apply and the time will run from the date of transfer. Even if you come to know after that, cannot be saved.
Your Lordship, kindly when I look at one appeal court's order.
Yes.
Page 12.
Page?
Inner page 12.
Inner page 12?
Yes. Appeal court or conta? What is the appeal court order?
Yes.
Well, I think that is the yes, appeal. It is appeal court order. ওখানে ওটা বলনো বলে আছে নাকি? ঠিকই আছে তো? Yes. 2014.
Internal page 12, yes.
Internal page 12.
Yes.
My lord.
Oh, that chart.
Chart, yes.
Yes.
My lord, Lordship kindly, the date of execution is 26/9/2014. Date of registration 21/10/2014.
So limitation will start to run from 21/10/2014. Because when it is registered in the book volume,
yes,
that's the starting point.
Date of preferring the application for preemption 10/3/2016.
It's absolutely barred, Mr. Moitso.
My lord, I have, my lord, that Barasat Eye Hospital.
No, Barasat Eye Hospital is on a different point. That's on the balance consideration, short consideration.
My lord, that's why, my lord, I am coming to that. My lord, even my lord, there also, and Abdul Mutin, my lord, that is also there. Abdul Mutin, perhaps.
Abdul Motin Mollik.
Mutin Mollik.
Parent judgment is Barasat Eye Hospital, but that is on a different aspect altogether. That was the earlier view from 17 because I appeared in Barasat Eye Hospital before.
Yes.
So in that matter, the previous view was that you can deposit according to your own valuation together with 10%. Yes. And after adjudication, the balance can be directed to be deposited. So in that matter, the Honorable Supreme Court has said no. Even if you challenge, you have to deposit the entirety. And in that matter, it has been said that the balance consideration also ought to have been deposited within the period of limitation. There also no extension. And here also, the amount is after that.
No,
so in both counts, you are gone, Mr. Moitso. Balance consideration also cannot be deposited subsequently.
And Lordship will give me 1 day time. On Monday, I will come back. I know my predicament. I appreciate, why not? I will take a chance.
Well settled, Mr. Moitso.
Well, I will take a chance. Well, let my I have not gone through the evidence and other things. Well, I do not.
Evidence is not necessary because this chart, if you cannot dispute this chart,
that's why I have placed it before your lordship.
Yes, if these facts are not in dispute, nothing, no amount of.
As far as well, intimation is concerned, your lordship saying.
Intimation section 5.5.
Section 5.5
is not.
As far as co-sharer, but
co-sharer there is, but not adjoining owner. You are claiming as an adjoining owner. I tried to make that argument.
Oh, no, I am saying a co-sharer, not adjoining owner. Not perhaps there is some confusion.
Oh, you told me adjoining owner. That is why. If you are a co-sharer, non-notified, then you will be getting 1 year according to Article 97. So
I was asking, madam, because I.
So even then it is more than that.
My lord, your lordship, kindly give me 1 day time. I will come back on Monday.
If it is of 1 year, it would be from 2016. 10th of March till 9th of March 2017. Yes. You have filed on July. And more so, even if I ignore that, The next is a short consideration that was also deposited beyond time. That's why Barasat Eye Hospital also comes.
Barasatai won't come.
Yes, it will come because here it was with a short deposit also.
Short deposit.
Yes,
That's I
in
let
the chart.
Yes.
Date of depositing of the amount
Yes.
is 2017. So Barasat Eye
1/4
Hospital also comes.
1/4/2017.
Yes.
Date of issuance challenge 3/4/2017.
Yes. And
Depositing
deposited
amount
on 4/4. So that is also beyond time, beyond limitation.
So that is. Well, let me go through.
After Barasat Eye Hospital, Mr. Moitro, I tell you, many preemption applications have been dismissed.
My lord, can you take
On
it?
Saturdays, miscellaneous matters days, the trial courts are keeping these matters, relying on this, it's being dismissed. Series of, that's what is being.
Well, let me come back on Monday.
The issue that arises for consideration in
On Tuesday, instead of Tuesday.
The issue that arises for consideration in this civil division application is whether an application under section 8 and 9 of the West Bengal Land Reforms Act 1955 can be entertained after the period of limitation fixed under the statute. First up, the other issue is whether the balance consideration amount could have been permitted to be deposited after the period of limitation. First up, Mr. Moitol, under senior advocate, appearing for the petitioner, seeks an accommodation to consider such aspect and to revert back on the next occasion. On the prayer of Mr. Moitol, under senior advocate, list this matter Tuesday. Next.
On item number 24, I am for the petitioner, madam. Madam, 24, I am for the
Yes, what is
petitioner.
this?
Madam, my 7-11 application has been rejected by the trial court.
None appears for the petitioner at the time of call.
My
No
lord-
accommodation has been sought for
My lord, I
either.
am for the petitioner, my lord.
CO number such and such stands dismissed for
My
default.
lord,
Yes,
my
next.
lord, my lord, I am for the petitioner, my lord. My lord, I am for the petitioner in item number 24.
Expeditious disposal of what? What is the stage of the suit?
Charge number who has been framed. And one application under order 16 and rule has not been yet disposed.
Order?
Order 16 and rule, order 16 rule 17.
Order 6 rule 17. Order 16 rules, order 6 rule 17. Issues have been framed. What is the next date fixed for order 6 rule 17?
It's a matter at 2 p.m. because I
This application under Article 227 of the Constitution of India is at the instance of the who are you? Plaintiff or the defendant? Is at the instance of the plaintiff praying for a direction upon the learned Civil Judge Junior Division Second Court at Barakpur to dispose of title suit number 357 of 2016 expeditiously. First up, from the order sheets appended to this application, this court finds that an application under Order 617 of the Code of
title as well as case number 48.
Title execution case. What is the JME's case for? Is it pending or it has been disposed of? This application under Article 227 of the, you are the degree holder.
Yes.
Yes.
Plaintiff petition for declaration on injunction, not made application for amendment because of the factum of partition was sought to be brought on record, not it was because
Yes, where is Mr. Banerjee?
he is on pilgrimage. He requested me to complete this matter Lord, at Mullikarjun. Yesterday he went on for the
Yes. Because he mentioned, I think, on Monday or Tuesday.
The matter has been fixed on 25th. That's why this urgency is
Yes,
not
yes.
helping him. Lord.
Yes.
And you take trouble to look to Lord, the item number 28, Lord, paragraph 4.
Item number 20, there are two civil division applications.
Lord, one is for rejecting my application under Order 6, Rule 17. When the application was pending before the lordship was at the Lord Jalpaiguri bench. Lord, the adjournment petition was made that since my lord is not there, it kindly grant adjournment.
That was rejected.
Not only rejected, not
No, that was the what is that revision application?
for
That is 2501. So rejecting Order 6 Rule 17 is 37 of 2025. Yes. Yes.
Now, Lord, only can you take trouble to that will be the position will be made clear, Lord. The predecessors, there were partition between the predecessors of the parties, Lord. It has been admitted in the written statement. In the written statement, it has been categorically mentioned it was partition. That was not due to oversight or something like that. Not it was not brought to the plain, not neither the during evidence. That's why not the application. The moment.
No, you are the defendant or the plaintiff. You are the plaintiff. Yes. What is the amendment? Please show me the application for amendment once.
Give me some time. Next is C. Yes. 45 residue. May I read this one?
Please give me a minute. Please give me a.
The reason behind this one. No dispute regarding the possession. Now the reason behind is not page 38 one. So also kindly take trouble to look to page 38. That is the written statement of the defendant. Paragraph
38. 38 is not the written statement.
Page 30.
38 is the affidavit part.
Perhaps the next file, but I am arguing on
37 of 2025. 37 of 2025.
No, item number 28, I am arguing upon the petition because this is comprehensive petition. We will get everything from that petition.
Yes, I'm looking at 28. CO 37 of 2025. You are placing CO 37 of 2025.
2501 to
That is 27. That is 27. Yes.
So page 38. Paragraph 11 is also kindly take trouble to look through. That I am reading not that these state defendants beg to submit that the co-scheduled property along with many other properties originally belonged to Pillbox, Nuruddin, Ainuddin and in equal share. During the joint ownership and possession, they by virtue of an amicable partition in or about 1935, they got all the properties partitioned, and by virtue of such partition, Pillbox and Ainuddin got the co-scheduled property exclusively in lieu of share of Nuruddin. Therein, he got plot number gap. It is very interesting. Plot number gap exclusively. Plot number was not given, purposely not. That's why I got the certified copy of the sale. It is not there. But that is admitted.
You are claiming from whom?
I am claiming the other that is Nuruddin.
You are claiming for Nuruddin.
The constitutional property, the defendant on the basis of arrest, the constitutional property after the date of Nuruddin. Two sons, namely Mominuddin and Mutia Rahman, owners of the constitutional property. That is that paragraph 2 of the petition. That admitted position was sought to be brought on record, no, that has not been allowed.
What was the original case in the plaint?
Declaration and injunction. Thus, they sought to record their names in respect of the property. That's why the suit was filed.
No, declaration or partition?
Partition was sought to be included, not
Oh, initially it was a declaratory suit.
declaration. This one not, I am 45 knows not judgment is not.
The learned advocate appeared.
Order 6/17. Subsequent other matter, the original matter he was already taken up. That is the rejection of my adjournment application. The other matters not.
দেখি দাঁড়ান কোনটা
Yes.
অগাস্ট 3 2024 ওটা ইমপ্লিমেন্ট অর্ডারটা কত ছিল
3/7 of 2025.
অর্ডারটা ইমপ্লিমেন্ট অর্ডার বলিনি না Sure.
the order to be set aside, that order.
What is the order? Rejected arguments. What is there?
Yeah.
Yes. এইটা থাকবে।
In this matter, my learned senior Vivek Jiti Basu is appearing for the petitioner. He has fell down on the floor and his ankle has been.
I'm here. I'm here. My lord, I fell down and broke my ankle, my lord.
When?
Yes, my right ankle, my lord, is multiple fractures. My lord, it will have to be after 15 if your lordship kindly allows me to come.
Yes, yes.
1.5 months, my lord. I do not know, it will take 3 months maybe. So at least 3 weeks, my lord.
Your Lordship, I appear
fractured
for
right
the opposite
ankle.
party, Your Lordship. I appear for the opposite party. Miss Chatterjee, her mother had passed away. She had come last day. So, Your Lordship, some rights are today. So, it can be posted on after Monday, Your Lordship. We have the urgency in the matter, Your Lordship.
There is no urgency, my lord. The matter was being heard out.
Lordship,
We have
there is
received
urgency.
everything.
Mr. Chaudhary had mentioned last day, Lordship.
After 14th, any day, my lord, I'll come. Even if I'm limping, I'll come and do the matter. Kindly fixes the date, my lord. Any day after 14th of September.
Yes, what is the urgency?
Your Lordship, Mr. Chaudhary had mentioned on Your Lordship on after Monday, Your Lordship, anything it can be posted, Your Lordship.
Yes, what is the urgency?
Your Lordship, I'm not engaged in this matter.
What order is under challenge? 135.
The NCDRC passed an order, my lord. And in that order, whatever payment was there, they've already taken out the money, more than 16 lakhs, thereafter 2.5 lakhs. Everything has been taken. Nothing remains, my lord. Now only possession, we want to give them possession also. In consumer dispute, my lord. Nothing remains. But this is a quorum non-judice matter, my lord. It was argued at length.
Your Lordship, on Tuesday it can be posted, Your Lordship.
Kindly makes it after 14, my lord, any day because of my grounds, my lord.
National Commission passed an order.
Yes. All the money which was also deposited took out. Thereafter, it took out even 2.5 lakhs last day. My lord, we deposit everything. It is a quorum non-judice order, my lord.
Why?
My lord, because the State Commission had only one judge, and the Supreme Court is equivocal in stating that one judge cannot pass an order.
No,
It's a
State
quorum
Commission. State
Yes.
Commission, one judge.
Yes.
Oh, thereafter, an appeal was preferred before the National Commission.
Yes. Yes.
So what did the National Commission say?
National Commission did not look into it. Straight away confirmed that order.
Yes, madam. What do you say to this?
Your Lordship, on Tuesday it can be
Supreme Court has
posted.
decided this issue.
Your Lordship, I'm not engaged in this matter. Your Lordship, on Tuesday it can be posted, Your Lordship.
My lord, after 14th any day, my lord, I'll come. If I'm limping, I'll come also, my lord. Kindly fix it, my lord. We have got a written notes and arguments. The
So
judgments.
this matter was mentioned by the learned advocate for the
Your Lordship, her mother passed
urgency
away.
you mentioned, you have to move. Yes, next.
Any date
Yes.
fixed, sir? After 14th?
It will revert back to its original position.
Okay, I'm
Yes.
grateful. I'm grateful. I'm grateful.
Yes. Oh, এগুলো সব ছিঁড়ে যাচ্ছে তো।
Your Lordship,
Yes.
Your Lordship, I appear on behalf of the OP1. Your Lordship, I am being led by Mr. Thakkar.
Yes.
I am praying if the matter could be taken up on Tuesday or after Tuesday.
No, no, madam. Yes. Who has mentioned this?
Yeah.
Yes.
Lord, I started this matter on the last occasion, my lord. If your lordship remembers, my lord, X took loan, my lord, from the bank. There are about 2 or 3 banks saying that I am the guarantor. My lord, proceedings were, my lord, drawn up. There was a time when, my lord, the proceedings came to me. saying that your father has taken money. So whatever the asset that you have, it will be auctioned. So I got afraid of that. I didn't even look into anything, Milord. I paid off that 1 crore or something, Milord, to the bank. 25 lakhs, Milord, is a disputed question. That's because, Milord, that was paid in cash. Push, sit down. That was paid in cash. Thereafter, Milord, I found out that my father had never taken any money, nor was he a guarantor anywhere. In the meantime, Milord, the banks have, Milord, merged, and Milord, one of the banks has sold off this loan to
Asset reconstruction.
reconstruction company. I filed a criminal case. In that criminal case, Milord, it is found that on the basis of which, Milord, the loan was granted is a fraudulent document. And in terms of the criminal procedure code, Milord, that document has been destroyed. Once that document got destroyed, I came back, Milord, in the suit and said, in the commercial suit, and said that it is an admitted position my father did not take money. It's an admitted position that you have taken money on a fraudulent
Admitted position.
Admitted position. I'm on 13A. That's
Where
why
is the admission?
I'll show you, Lordship, that everything. I'll show their document where they are saying where the bank is the reconstruction company is telling the bank that it is because of you this has happened. If there is a liability, you will have to pay. That it's gone to that level. Then what happens is that it's a fraudulent document was proved by the criminal court. In the criminal court, there were proceedings, and that document on which they were claiming this loan was taken has been said to be fraudulent and destroyed. Now, I file a suit here and said that, look here, this is the money that you have taken from me on the basis of a fraudulent document. Kindly give back the money. I filed the suit. Initially, an Order 38 Rule 5 was filed, where the Supreme Court directed the money to be secured. That money, they have secured. Now, under 13A, there is a provision that if it is unlikely that the other side will have a defense, the degree will be passed at least to that effect. Not to the entire, because I am saying today 25 lakhs is something that I will have to prove. But the other money, with respect to 1 crore, 21 lakhs, that's an admitted position that you've taken from me when my father didn't even take a loan, nor was a guarantee. The learned judge says, that this is a question which has to be decided and dismisses my application, against which I am before your lordship. So I need to show your lordship first. I'll go step by step, not the entire. Kindly first have a look at the impugned order once.
Yes.
Takes up below the first page itself. I'll place it for your lordship's consideration. But before anything, Milord kindly turns to page 4 bottom. That thereafter, 9th of March 2023, the plaintiff filed the instant suit before this court. This is important. The fact is important. On 15th of September.
Chatterjee, this is a hearing matter, Mr. Chat.
It is
to be hard.
I bow down to your lordship on that. I'm not saying, Milord, it requires hearing. But then,
There's
Milord,
no
my
scope
money
to pass any interim order now.
My money is stuck. Allow me to take the money whichever they've kept. I will give indemnity, saying that if I lose, I'll give the money back.
That's you can. I can give you liberty to make an application there for return of that money. That liberty I can give. But with
Return of
regard
the
to
money,
this,
Milord,
whether this
is their application on that. This is where.
for
This is the application basically.
no, you said that your order 13 capital A application has been
Basically,
rejected.
it's that.
So it's a
But the
decree.
main
Decree
suit
was not passed.
You had refused Order 13 rule.
Yes. So according to you, you wanted a decree then and there
Interim.
because the defendants do not have any.
Basically, Order 12 Rule
Yes.
6. Basically, Order 12 Rule 6, a little more than that, because Order 13 Rule A says.
No,
that if
Order
they-
12 Rule 6 is admission.
Admission. Here
Here
it
is
says
they do not have,
unlikely of a
either the
defense.
plaintiff do not have any case or the defendant do not have any valid defense.
Fine.
So on the prima facie, if it is found,
Fine.
it has to be hard. This you have mentioned for upgradation. What
Well,
was
this
the,
was
what
taken
was
up by
the,
Justice Justice Shampa Sarkar had heard.
shall make the entire matter infructuous. This is the ground
It
on
will-
which.
Milord, if it has gone for case management, Milord, commercial court, then this becomes infructuous, basically. If it is decreed, it's not infructuous, but then
Ashun, hard. Yes.
cannot proceed through this. টাকাটা proceed করলে কি কি পাই?
But I am for the petition, my lord.
Yes.
My lord, on the earlier occasion, my lord was inquiring about the fact that who was the appearing advocate in the lower court, my lord.
They've ascertained who are the advocates.
My lord, Devashish Chaudhary, my lord.
Chaudhary?
Not Chaudhary, my lord.
Chakraborty,
Chakraborty.
since I'm not inclined to take.
I'm for the petitioner, my lord.
Yes, Mr.
But
Raj.
the applicant for exhibition is hearing of a suit for restoration of position. The
Conjugal
applicant,
rights.
my lord,
What is the stage of that suit?
My lord, issue date 3rd July, date fixed for paying of issue, 3rd July, but no date thereafter, my lord, fixed till date, my lord.
Injunction disposed of.
Yes, my lord, disposed of. On that date, my lord, date fixed on 3rd July for payment of issue, but no date thereafter fixed for payment of issue or anything else. Petition has given out.
What is the next date fixed?
Nothing, my lord.
This
Nothing.
application under Article 227 of Yes. None appears for the
Your Lordship, this matter kindly remember where the impounding, prayer for impounding is being rejected since the very execution of the document is being challenged by the plaintiff. It's an unregistered document.
Why it was adjourned on
Because
oh.
Your Lordship wants the evidence.
Yes.
But without wasting Your Lordship's time, Milord, the question number may I place, Milord, which are relevant for Your Lordship. Kindly takes up, Milord,
whose evidence?
PW1 cross-examination dated 21st of August 2024.
PW1
cross-examination, Milord, dated 21st of August 2024.
Yes.
Kindly takes up, Milord, question number 15, 16 and 23. This is, Milord, confrontation. Now, Milord, DW1 witness, if Your Lordship takes up the examination of DW1 dated 29th of November 2024.
PW1, 29th of November, yes.
November. Milord, kindly takes up point number 8, Exhibit C and C1 with objection. At this juncture, Milord, the impugned application was being filed.
Let the new register, what is this word in handwriting? Let the, after exhibit C/1 with objection, let the
registered document. Milord, it's
prior to registered.
Milord, it is not relating to, Milord, this exhibit because this document is admittedly not registered.
Yes.
And according to me, this is not a compulsorily registrable document. Milord, that is neither here nor there.
Yes, yes.
That is at this stage
But
of.
where is that document here on this? This is a different document then.
Yes, this is a different document.
Yes.
That has been already marked as C and C1. That I have
Yes,
shown
yes.
before Your Lordship.
But
This
then it
very
has also
document-
been marked as Y for
That's
identification.
not, I am not concerned, Milord, that's not
Yes.
challenged by my client.
Yes.
So, Milord, at this juncture, the impugned application has been filed and I have shown before Your Lordship the impugned order. If Your Lordship takes up the order.
So according
now,
to you, that was filed on 29th of November 2024.
at the time of, Milord, confrontation at the PW witness cross-examination, this has been done. Subsequently, when my turn came, DW1, Milord, produced that document. And now I want impounding, the learned judge rejected on the score that plaintiff have denied the execution of the same.
Please show me the reasons for
Yes, Milord,
rejecting.
if Your Lordship takes up the order number 56, kindly
Yes.
takes up the second page without disturbing Your Lordship. The other part I have placed already. Milord, the sentence starts with, but this court is of the view. Has Your Lordship got it, Milord?
Yes.
For impounding any document or instrument under section 33 of the Indian Stamp Act and its admissibility under section 35 of the Stamp Act, the existence of such document or instrument is condition precedent. Here in the case in hand, the plaintiff who is alleged to have executant of the alleged instrument has specifically denied existence of such instrument or its execution. Therefore, the actual existence of the alleged instrument unregistered document of declaration itself is in question. Neither of the parties filed any application for specific investigation of the signature of the plaintiff appeared or impugned document or instrument which admitted signature of the
What is the
plaintiff.
nature of the document?
It's a declaration.
Declaration of what?
No, Milord, it's Milord,
Where is that document? Have you annexed that? Where is that? Do you have a copy of that?
I don't have right now, Milord. It's a document, Milord, containing a declaration approval that he is handing over possession, Milord, for Milord to use the said land, acknowledging my previous possession. That's the
Where is that? Where is that declaration?
That's the contention, Milord. Mireda.
Please show me the declaration.
But the declaration is
Because
right
is it what is the stamp that is to be paid?
That's Milord. The registry office will be Milord ultimately ascertain.
Under which clause? Is it a compulsory registrable document?
No, registration. I'm praying for impounding.
What is the impounding with
impounding
regard
is
to
for-
the deficit court fees? Sorry,
Milord,
deficit
that's for
stamp.
Stamp.
So what is the how it is to be stamped under the Stamp Act?
Under this, that's Milord the exercise that's to be needs to be
What
done.
is your what is your contention?
No, Milord, my
Does it
contention
require
is
stamping?
according to
Please show me from which provision. What is the nature of the document? Where is that document, Mr. Mukherjee?
I have not that document is.
You don't have a copy of that.
Since Milord, the reasoning of the learned trial judge is itself.
Reasoning may be there. Reason can be supplemented. But please show me what is the
Learned
nature
judge
of the
is
document.
opinion that
Under which clause it comes.
if your lordship takes up the plaint, Lord, may I take your lordship? Lord,
Yes.
it's a declaration of title and permanent injunction. Kindly take
Yes.
my written statement, paragraph, Lord, page 24, paragraph 12.
Yes.
It's an acknowledgement of my possession over the property.
Does it require stamp?
Lord, this acknowledgement will since
Show
they
me
have-
under what provision it requires stamping.
because
Reasonings may be wrong, but if the document does not require stamping, why it should be impounded?
this is ultimately goes root of the matter, since my right is based on rather my
Impounding.
defense is
Prima
based on-
facie, Mr. Mukherjee, prima
the
facie.
court has to, then the court has to come to, because today I have raised the issue. The court may say that it doesn't require any impounding. In that event, at the time of argument, this point of insufficiency of the stamp duty and I cannot rely upon the very instrument, this will not come. Either the court has to come to a conclusion that very well, whatever you prayed for, as per the Stamp Act, the stamping is not essential. Then, Milord, it is not a flaw on the future date when at the time of argument I will try to rely upon the document.
Mukherjee, at
Because
the
I
time of
invited the court-
impounding,
Yes,
prima facie
yes,
satisfaction.
Milord,
has
I
to
bow
be-
down before your lordship. Your
So,
lordship can direct that.
otherwise, it will be a
Milord, I bow down.
every document which does not require
This cannot be a
please impound,
thumb.
please send.
This cannot
This
be a
cannot
thumb
be
rule.
the-
Your lordship can remanded the matter back, directing
Show
that.
me the document.
Document is right now not with me, Milord.
That's the basic document, Mr. Mukherjee.
That's true, Milord. But
Then
Milord, may I serve and come back? May I serve and come back? Milord, I shall.
please bring the document. You can serve, but no stay.
But 25th is the date fix. It's a declaration of title and injunction. Milord, I will come back and show before your lordship.
But,
Or your lordship can, on the next, your lordship can make a short date of returnable so that, Milord, the reasoning, whatever, Milord, this exercise for the first time before your lordship, Milord, under Article 227 is not, Milord, warrant. So when the learned judge has not gone into that aspect, your lordship can always direct that after considering that whether any stamping is necessary or not, the learned judge will decide afresh. Only on that score, Milord, I am not, and I will serve and come back. Your lordship made a short returnable date. The entire tenor of the order is that since the existence or execution is being denied, I have shown before your lordship what is the cross-examination part of the PW1. My defense is based on this instrument. My apprehension is that in future, if some ploy is taken by the plaintiff that this is the defect of the very instrument, then the
Mr. Mukherjee, learned advocate, appearing if you want, you can take back this. You can make a because that's good. Yes. Definitely. Yes.
My lord, it is with regard to we file an appeal in a judgment and a decree that is for eviction, my lord. We are the tenants there. For 70 years, we have been a tenant, my lord. And the tenancy.
What is the impugned order? What is the impugned order?
My lord, we have seeked out and stayed in regard to in an appeal, my lord, where the execution case they have filed up. So in that case, we wanted a stay and occupational charges were being made as a conditional for giving the stay, my lord. So
Yes.
my lord, what the thing is we are ready to give, but what is the thing, my lord? Actually the rent was 100 rupees per month, my lord. And the suit is
5,000 you are challenging.
No, my lord, is kindly see the conditions.
This is vacate.
I'll place out one.
Please vacate the property, get a better accommodation. You did not spend that 5,000.
And since 2024, my lord, following this revision application, they are praying for time.
My lord, kindly take this one, my lord. One judgment of our own High Court, my lord. That is para 8, para 31 and para 33, my lord. And one Supreme Court judgment.
Para?
Para 8, para 31
For what
and 33.
proposition?
My lord, a special officer was been appointed into that. See out the factor of the building. My lord, kindly take the condition of the house, my lord.
But this is, my lord, this has not been produced before the court.
All right, I'm doing one thing. I'm setting aside the order of stay along with the occupational charges. I will direct the learned trial judge to decide it afresh because it has to be a composite one. Unconditional cannot be done. I'm setting aside. I think Mr. Mukherjee will not oppose.
No, my lord, may I say?
I will direct
My
the.
lord, before the learned court below.
These all tiles.
Before
All right, I will vacate the stay also, not only the occupation charges, because it's conditional. So both has to go.
But since 2024,
Both
they
has
are
to
not
go.
paying anything.
Let the executive court, appellate court decide on that.
It's 50 times higher, my lord. It's 50 times. It can be seen one more judgment now where Supreme Court had decided 47 times it was done, my lord. Where
All
it
right,
has
come at
ended
2
in
p.m.
para 8, my lord.
Come at 2 p.m. You have brought those judgments
But
starting from Attaram.
Absolutely.
Yes.
And not only that, my lord, before the court below, my lord, we filed the documents wherefrom it will appear the rent is more than 12,000. My court has reduced 5,000, but we have agreed. We have not challenged. We can't say anything. Now, my lord, the
That
document
is, in the stay application, you have
in the stay
objection
app-
to the stay application is filed. All right, come at 2 p.m. Please bring all the judgments.
Before my lord rises, my lord, item number 71 in today's list, my lord, you had mentioned this matter, my lord,
71
of
Yes.
today's list. My lord, 28th is the next date. My lord, there is already a Supreme Court direction for the my lord, learned executing court, my lord, to conclude within 4 months. Almost 3 months, my lord, has elapsed. Now, only because my lord had my lord, granted them a liberty to take adjournment for a day. Every
Yes.
day, my lord, that order is being shown. And my lord, a decree, my lord, I am not being able to execute, which was affirmed till Supreme Court.
All right, 71. Let me see how far I can proceed.
My lord, may it
Because
appear
there are
as
only
to
two,
be
three matters in this, then I will be.
May it appear, my lord, as to be mentioned on Monday so that I can just indicate and my lord fixes a date then.
List this matter. Yes.
But I'm not denying about the occupational charge, but I'm only saying about the factor 50 times per. 100 rupees was the rent month. And it
Let me see, where is the application?
The application is at page number 50.
Please show me the decree. What is the extent of occupation? What is the decretal property?
The decree is there. The entire judgment starts from page 28, Malad, and till page number 43, Malad. Malad is in a village called Podra, PS Sakrail, Malad.
Podra is not the village, my lord.
Malad, there's no holding number. It's written village and post Podra, Malad.
Where is your application for stay?
Malad, it starts from page number 50, Malad. 50, Malad.
Where is their application for occupation charge?
The appeal occupational charge, Malad. Just a second, Malad. Page number 54 it starts with, Malad. Malad, it comes under Panchayat area. Malad, I have set out, the petitioner have filed the instant appeal for setting aside the judgment on the decree 20, that is page number 54, Malad. dated 26/4/2024 as prayed by the learned trial court in connection with title suit 1038 of 2019. The respondent in plaintiff filed a suit for eviction being title suit 1038 of 2019 before the learned trial court against the appellant defendant on such false and frivolous facts and grounds as set forth in the plaint, that in connection with the aforesaid suit on contested hearing, the learned court has pleased to pass the judgment and decree dated 26/4/2024. In pendency of the incident, the title appeal by the plaintiff respondent doing illegal high-handedness activity by the dint of impute judgment and decree as such operation of judgment and decree dated 26/4/2024 is required to stay till disposal of the instant appeal for the ends of justice. Otherwise, the petitioner shall suffer irreparable loss and injury. The petitioner have a strong prima facie case in every chance to success in the instant appeal. The petitioner bona fide and ends of justice. Hence, it is prayed that the honor would graciously please to pass an order of stay of operation of the judgment and the decree dated 26/4/2024 as passed by the learned trial court in connection with the title 1038 of 2019 till disposable of the instant appeal. My lord, thereafter, my lord, my affidavit also is very clearly stated, my lord, residing at Podra Khea Ghat, village and post Podra, under Panchayat, my lord. My lord, their opposition starts at page 56, my lord, where they have set out in para 5, my lord. The suit property, decretal property, is situated as well-known locality at Howrah, which has mixed occupancy, that is commercial and residential, railway station, market, school, college, main road, and all the nearby location. At the suit property, naturally at the time of disposal of the said application, prevalent market value of the locality is required to consider by this learned court. They had seeked out this for my lord, para 5, my lord, in their objection, my lord. Now, my lord, what I say, my lord, let it be decided, because for 70 years I have been occupying 100 rupees, even it is a tile shed, my lord, under the panchayat area. If a reasonable, my lord, that is
What according to you is the reasonable amount?
my lord, because if in the
No,
audit,
I'm asking you, what according to you is the reasonable amount?
it could have been, my lord, 1500, something like that, my lord. 15 times it could have been, my lord. 15, 20 times, my lord. Because, my lord,
You were inducted when?
70 years back, my lord.
70
My
years
father
back.
was there.
At that point of time, what was the amount of rent?
My lord, that I won't able to say. It may be some few rupees, it may be. It may be a few rupees into that, my lord. Because at that time,
When it became 100?
That I have to get out an instruction, my lord. Even, my lord, from the photograph, it can be seen, my lord.
You have not produced that photograph before the learned
My lord, that is,
appellate court.
I don't have the instruction in regard to that, my lord. What my learned friend has said, my lord, I don't have the instruction whether they have produced it before the court or not. Even the finding of the court was that, my lord, prime means he says out it's a my lord, at the page number, the first page, my lord, only one line has been taken into consideration. That is the last paragraph, my lord. On consideration of the same, I find that as per the schedule of the plaint, the suit property is situated at prime location at Howrah, my lord. But, my lord, it's not a prime location altogether. It's a panchayat area. It can be detected, my lord. It can, a special officer can be there. Even one more judgment I placed out, my lord, at
Yes.
that time of the Supreme Court, my lord.
একটাও দাও
Para 8, my lord.
রেফারেন্সটা বলো
এটা হচ্ছে এক সেকেন্ড তো এটা নিল নিয়াজ আহমদ খান para 8, my lord, where it has been said by 47 times it was there, my lord. 140 rupees, 150 rupees was the rent, my lord, where it was been enlarged to 47 times, my lord. Here also it is 100 rupees, it was been enlarged to 50 times, my lord. If a reasonable occupancy charge can be taken, my lord, that is only the prayer which I have been seeking, my lord. On the basis of taking into the factor of the place of my area which I have been occupying, my lord, and what is the condition of the locality, my lord. Is the locality is not what has been set out as a prime, my lord. It can be found out from the itself from a report if it has been filed. If a special officer has been appointed, my lord, it can also find out into that. Let that be taken into some consideration of the factors should be taken before deciding what should I pay.
What is the stage of the hearing of the appeal?
The hearing. Kindly, I have produced the last order, but it is a fix for hearing, argument.
When?
But I have last time handed over the certificate copy to your lordship,
11th of September.
11th of September.
Yes. Yes, Mr. Mukherjee. What do you say?
Actually, my lord, this matter was of Animesh Paul. He has not joined the court up
But
till now.
before the learned court below,
Matter, an advocate on record in this matter is Animesh Paul. He did not join up till now. On the last occasion, I had taken time and adjournment, my lord. So he told me, you conduct the matter.
No, I could not follow. He told you?
You conduct the matter.
Yes.
The reason, if a lot of instructions may have to be taken, which are not with me, my lord, at present.
Yes.
but first of all, it is not suit for eviction of a tenant. It is a suit for eviction of a licensee. Our specific case, if your lordship see once, our plaint, your lordship will kindly straightway come to the plaint where we have page 9. Page 9, paragraph 5.
Yes.
That since his predecessor in interest of the plaintiff, the defendant was permitted and granted to stay the suit room as leave and licensee basis without any license fees. Now, my lord, thereafter they did not vacate. Now, my lord, this eviction proceeding has
So
been
that was license without license fees.
without license fees.
He's saying 100 rupees is the rent.
Yes, my lord. My lord, if the suit property is taken 1200, even in the written statement is very clearly, my lord, stated.
This
into
is
that.
our case.
Yes.
Now, my lord, if your lordship see, we have in our written objection, we have categorically mentioned it is the suit property, suit premises is situated in the populated area and in the marketplace. Because if your lordship
But
see,
you have
well,
not stated any rent. What will be the amount?
yes,
That you
now,
have not stated.
Now court says that my lord, what are the documents? Now, my lord, on instruction, my lord, specific instruction, my lord, we produce the
But that is not recorded, Mr. Mukherjee, in the order.
in the order it has not been. We have produced very well. My kindly see, court has come to a specific finding. My lord, kindly
What
see.
is the document you have produced before the court? Please show me.
But the document, my lord, the এইমাত্র ডকুমেন্টটা ছিল এখানে কোথায় গেল? This is the, my lord, the valuation of the property at that area.
Valuation of the property is.
If the
With
valuation
regard to the market rate of rent, what document you have produced?
market rate of rent, my lord, the valuation of the property, and we produce one document that is 8,000 rupees.
Where is that?
But that document, truly speaking, is not with me.
8,000 of what is the next?
Now I'm telling you, lordship. Now kindly see the schedule of the property.
Yes.
My learned friend is
So
saying.
let the appellate court decide what will be the amount. Nothing. You have also not stated the market rate of rent.
I'm showing to you,
You have not produced any document.
But he wants to produce some photographs, my lord. If your lordship see, but these are the photographs. His four-wheelers are parking and everything was parking there.
This is my
No, whatever it might be, the photographs.
Very
So
well.
let the appellate court decide. I give you liberty to produce the documents before the appellate court.
I leave
Because
it
there
to
was no material before the appellate court for this.
it is there. But court has come to a conclusion. Court
On the
has.
basis of what?
But if your lordship say this, then my lord, kindly consider, my lord, from the Attaram, my lord, and the other following judgment, while court granting an order of stay, court has to prima facie found that there must be a condition so that
Mr. Mukherjee, this occupation charges.
but this will
has to
create a
be-
delay. This will create a delay. It is my submission. I leave it to your lordship, whatever rent your lordship will fix, but kindly expedite the appeal. Now, my lord, the judge, your lordship asked me to bring the judgments, my lord. Now, my lord, the Attaram was the the judgment which he relies, but kindly see once, my lord, then I will place my judgments. The judge.
Para 8, I'm saying, my lord.
Which judgment?
On the Supreme Court, my lord.
The Kishe-
Niaj Ahmed Khan, my lord.
No, Badal Chandra Gorai.
That is one I gave out. That was, and even
Badal Gorai has not been supplied to me.
What judgment he has given to you?
He has given
Niaj Ahmed Khan, my lord.
Niaj Ahmed Khan.
Yes.
From Manupatro.
Paragraph 8.
Now, my lord, this is in respect of complete different. My lord, may I just read? The appellant is a tenant and the respondent are the landlords. On allotment of the premises, which is the subject matter of the proceedings up to the appellant, the rent was fixed 150 per month under section 16(9) of the UP Urban Buildings Regulation. Then, my lord, the presiding authority dismissed the petition for eviction, and that was confirmed by the appellate authority by dismissing the appeal by the respondent. Feeling aggrieved by the respondent, filed the writ petition before the Allahabad High Court. While admitting the said writ petition filed by the landlords, a learned single judge of the Allahabad High Court issued an interim direction dated 17/10/2006 to the tenant to pay rent at the rate of rupees 12,050 per month with effect from October 2006, with a further direction that if the rent at the rate is not paid for 2 consecutive months, the landlord could evict the tenant by coercive process and with the aid of police. The learned judge has justified his interim direction on the ground that in exercise of writ jurisdiction, the High Court can reasonably increase the rent so as to bring the par of the prevailing market rentals. The increased rent was assessed in the following manner. The tenant has challenged the said interim order of the High Court in this appeal by the special leave. The premises in question is governed by the provisions of the Act. The said Act contains provisions relating to fixation of standard rent and for increase in rent, whereas where the statute specifically provides for fixation of rent and increase in rent, it is impermissible for the High Court to ignore those provisions, and direct the tenant to pay an arbitrarily assessed rent. Neither the power of judicial review under 226 nor the power of superintendent under 227 can be exercised. I am admitting because there is no eviction decree. He remains tenant. Therefore, when he remains tenant, he ought to have applied before the rent controller for
Para 8.
Allow him to make his submission. Yes.
Now there is no eviction decree. Now until there is a eviction decree, my respectful submission, court cannot increase the rent because the landlord has to approach before the rent controller for increase. Therefore, in the case in hand, and this judgment subject to correction. If I read the paragraph 8 also, we should have a note that the distinction between the cases where a writ petition is filed by the tenant challenging the order of eviction and seeking stay of execution thereof, and cases where a writ petition is filed by the landlord challenging the rejection of a petition for eviction. What we have stated above is with reference to the writ petition filed by landlords. In writ petition filed by tenants, while granting stay of execution of the order of eviction pending disposal of the writ petition, the High Court has the discretion to impose reasonable condition to safeguard the interest of the landlord. I am on it. But even impose reasonable condition to safeguard the interest of the landlord, but even in such cases, the High Court cannot obviously impose conditions which are excessive, arbitrary and opposite, thereby making the order of stay illusory. When a tenant files a writ petition challenging the order of eviction, the High Court may reject the writ petition if it finds no merit the case of the tenant, or in some cases, the High Court may admit the writ petition but refuse to grant stay of execution, in which event the tenant may be evicted but can claim restoration of possession if he ultimately succeeds in the writ petition. Or in some cases, the High Court finding the case is fit for admission may grant stay of eviction with or without conditions, so that the status quo is maintained till the matter is decided. Where the High Court chooses to impose any condition in regard to stay, such condition should not be unreasonable or oppressive or in.
This is better. You are relying upon paragraph 8. So no stay, you vacate, you succeed in the appeal, you get restoration. This is paragraph 8. I think that's the best thing. Vacate.
A reasonable amount should be allowed.
Let it be. You don't have to pay anything. You don't have. Paragraph 8 has been stated
for
this.
70 years, my lord.
So you are relying specifically relying on paragraph 8. So it's
not 70 years.
My lord, for Honorable High Court,
don't pay.
33.
Don't pay. Please vacate. You succeed in the appeal, you will get restoration.
The Honorable High Court in
that I will make observation. That if you succeed in the appeal, you will get entitled to possession. Within 15 days, you will be restored. Your possession will be restored.
A reasonable occupational charges, even an Atharam.
Don't need to pay anything.
He is running.
Please, that has also been said. It's the discretion. It's the discretion of the court to pass either way. So that discretion can be exercised in that way also.
In our Honorable High Court, which has decided where a special officer.
You are relying upon the Supreme Court judgment.
That was also
High
taken
Court,
into consideration. That judgment which the Honorable High Court has come out with that. In that, this judgment was taken into consideration. That's the reason I brought out this judgment, my lord. Because
Yes,
that
that is
took
what
out
I'm
a
saying.
feature-
I will be
And
relying
that has
upon
been-
this
that
paragraph
has been
8.
My lord,
followed in
even in that also the judgment it can be seen, my lord. in
Now,
paragraph it has
144
been
bar, that has
taken,
been
my lord.
followed in recent judgment, 2025-23. I'm showing to your lordship.
The Badal Chandra Gorai also, that judgment has been relied upon, my lord. Kindly take into the paragraph number 31, my lord.
Yes.
Badal Chandra.
My lord, it has taken, this judgment has been taken into consideration. The Honorable Supreme Court in Niaz Ahmad Khan was pleased to observe as follows, my lord. We should, however, note that the distinction between cases where the writ petition is filed by the tenant challenging the order of eviction and seeking stay of the execution thereof, and the cases where the writ petition is filed by the landlord challenging the rejection of the petition for eviction. What we have stated above is with reference to the writ petition filed by the landlord. What we have stated above is with the reference to the writ petition filed by the landlord. In the writ petition filed by the tenants, while granting stay of execution of the order of eviction pending disposal of the writ petition, the High Court has discretion to impose reasonable condition to safeguard the interests of the landlord, but even in such case, the High Court cannot obviously impose conditions which are ex facto arbitrary and oppressive, thereby making the order of the stay illusory. When a tenant files a writ petition challenging the order of eviction, the High Court may reject the writ petition if it finds no merit in the case of the tenant, or in some cases, the High Court may admit the writ petition but refuse to grant stay of execution, in which event the tenant may be evicted but can claim restoration of possession if they ultimately succeed in the writ petition, or in some cases the High Court finding the case fit for admission may grant stay of eviction with or without conditions, so that status quo is maintained till the matter is decided. Where the High Court chooses to impose any condition in regard to the stay, such conditions should not be unreasonable or oppressive or in terrorium. Adapting some arbitrary figure as prevailing market rent without any basis and directing the tenant to pay absurdly high rent would be considered oppressive and unreasonable even when such direction is issued as a condition for stay of eviction. High Court should desist from doing so. Para 32, my lord. Upon perusing the order passed by the learned court below, although it cannot be said at this stage that the occupational charges fixed by the learned trial court, it is in terrorium, the said order lacks material particulars for accepting the contention of the degree holder, opposite party, and arriving at a finding that the occupational charge of the suit property should be 4,500 per month. A tenant under West Bengal Premises Tenancy Act 1997 is liable to pay fair rent. In the event of a dispute, fair rent is determined by the rent controller under Section 17 of the West Bengal Premises Tenancy Act 1997. Although a rent controller does not have jurisdiction to determine fair rent, after the decree of eviction is passed and the power to determine occupational charge rent is exercised by the Court of Appeal or Revision or a trial court in some circumstances, but the court have to determine occupational charge which is fair and reasonable. In order to determine fair and reasonable rent, the court should consider the area of the suit property, the age of the premises, physical condition of the premises, facility available to the tenant in the suit premises, if necessary, valuation of the suit premises upon appointment of a valuer. Upon taking these aspects into consideration and upon taking into consideration rent of similar type of premises in the locality, court may fix rent, occupational charge, which is in the opinion is a fair and reasonable. As the learned court has not taken into consideration the fact as mentioned above in fixing occupational charge, the order passed by the learned court below cannot be sustained, as same should be set aside. The matter should be reconsidered by the learned court below upon consideration of a report of a special officer to be appointed by this court. Thus, Sri Bidayak Lahiri, Learned Advocate, High Court, Calcutta, have seat at Bar Association, room number 15, mobile number such, is appointed as a special officer to conduct the inspection of the suit property. The learned suit special officer shall, upon notice to the parties, visit the suit property, take photograph of the suit property, photograph of the inner wall, the wall, floor, and the ceiling. The learned special officer shall also record the age of the premises and the photograph of the surrounding. Upon taking photographs and upon inspecting the suit premises, the learned special officer shall mention the condition of the building in that report. The special officer shall, upon receipt of this order, complete the inspection within 3 weeks and submit the report within 1 week thereafter. Learned special officer shall be entitled to a remuneration of rupees 6,000 to be paid by the petitioner. Incidental costs incurred by the special officer shall also be borne by the petitioner. Copy of the plan shall be served upon the special officer by petitioner. Hence, this revision application stands allowed. Order dated 7/10/2023, passed by the learned civil judge, Junior Division First Court, Alipur, South Chobis Pargana, ejectment execution case number 25, 2023 arising out of the ejectment suit 166/2017 is set aside. The matter is remitted back to the learned court below to reconsider the issue of the occupational charge upon receipt of the report of the learned special officer as observed above and by the reasoned order. It is clarified that there shall be a stay of the execution case till the occupational charge is decided. Upon deciding the occupational charge, the learned court below shall decide the application for setting aside ex parte decree being Miss Case number 53/2023 very expeditiously without granting unnecessary adjournment. So, my lord, here also what I say, my lord, let it be decided on the basis of some factors, my lord. That is only I
Deposit a lump sum amount. I will direct them
My lord,
to, that will be adjusted. That will be adjusted. I am directing an officer to be appointed, valuer to be appointed. But according to you,
partly used as commercial, partly residential.
according to you, it's 1500. So when the decree was
Well,
passed,
it is my suggestion, I said.
yes.
My
That is,
suggestion,
I'm
I said.
accepting your suggestion. When the decree was passed,
But decree has been passed on 2024. Even
2024 of
24th April 2020.
April. So
26th April 2024.
yes. So
But unfortunately, the court passed the occupation charges from the date of filing of the stay application. I don't know why.
No. That will be so from April 2024. So it's 12, 24, April, May, June, July, August. So 28 months. 28 months into 256, deposit 60,000. Deposit 60,000. I'm directing an valuer to be appointed. That will be
a bit lesser, my lord, if can be given, because these are labor, my lord.
But labor,
labor. I'm accepting your valuation.
My lord,
I'm accepting your
accumulated
valuation.
amount can be deposited,
Please
my lord.
put it that amount. I will direct this occupation charges to be decided on the basis of materials. I will remand to the learned appellate court. Both of you will produce. This is a tentative, a lump sum amount. Please
My lord,
deposit.
let the lump sum be given at 40,000 rupees.
But he is the owner of 4
I'm
commercial
accepting your
vehicles.
suggestion, sir. 1500, I'm accepting your suggestion. But some time will be taken. So I will direct by November. It is to be decided till November at your rate. Deposit 60,000. By 15th of September, I will direct. And if you don't deposit, then the stay will be vacated. The execution will proceed.
What your lordship thinks are better, my lord? It's
But kindly
If you want, I will remand that.
But
No
kindly,
difficulty, but you have to, according to your rate, you have to deposit. You have to show your bona fide. That will be adjusted. I will make that clear. If it is found that it's 500, so it will be adjusted against that. Balance will be returned, but you deposit an amount.
I'll deposit the amount in what is reasonable, my lord. What your lordship?
No.
What falls from your lordship, I find out reasonable. It's not that I'm going to work out on the basis of petitioner or respondent. It is what your lordship has fallen from your lordship. I find out that, my lord, it should be reasonable. If things are reasonable, my lord, your lordship says out, that is acceptable. If he doesn't accept, my client doesn't accept, then he has to suffer. That is very clear to that.
may I now please?
Yes.
Now, my specific case is that he is using the same partly commercial, partly residential. Why partly commercial?
So Mukherjee, do you want to fight
No,
with the occupation charges?
1,500. I need.
So Mukherjee, do you want to fight with the occupation charges, or you
Because
want
what
the
will
appeal
happen?
to be
I'm
heard?
telling your lordship. Suppose today, your lordship can fix the occupation charges. Otherwise, it will cause a delay. Now, before the High Court, ultimately, if I succeed in the court below, in the second appeal, suppose the appeal admitted, they will take this plea that this honorable court fixed the occupation charges such and such. Therefore, if ultimately admitted. Now, the question is, kindly visualize the situation. But had it been the case, he is in occupation residential, but 1,500 can't be because this is the place. It is near the West Bank Hospital, Howrah. Now, I have specifically stated, kindly see the impugned order. I have specifically stated on in their application, they have not stated that they are residing in a village. There is no that is long ago from the main road, everything. Nothing has been, the condition which is required to be made or the statement, no statement. I am showing their application. Kindly see once. Their
application of what?
Order 41, Rule 5.
Yes.
Order kindly see once, page 54.
Yes.
The petitioner has filed the appeal. The respondent filed the eviction suit. The contest that if the pendency, paragraph 4, only this is the statement, paragraph 4.
Yes.
Now kindly turn to, because someone has to make out a case. Where is their case? That the rate of rent should be 1,500 or 1,000. No case has been made out. On the contrary, in our objection, kindly see page 56, paragraph 5. But we have specifically stated that it is a mixed occupancy. Page 56, kindly see, my lord, our objection. Paragraph 5.
Sir, please consider one thing.
My lord, I have written
Here,
this one. Yes, my lord.
I'm telling a different thing. Here, the order has been passed from the date of the
I ought to have challenged.
from the date of the order. Please consider this. But the law is from the date of the decree.
Decree.
So if you want to challenge this set aside, then after remand, you know. Now you apply your mind. I can direct the appeal to be disposed of by November. Now you can decide. If you want remand, I will remand, but then it has to be from the date of the passing of the decree.
Now they have to make out a case.
But even in
months.
my lord, in the
It's 28 months and you are paying for 6, 7 months. Please think of that matter. Now, its choice is yours. Choice is yours now.
my lord, as your lordship thinks out is
The way, if you want, yes, remanded, I can remand that.
it can
considering my case, my lord. But I have specifically mentioned in my objection.
No,
that
Mr. Mukherjee, yes. You want
my
to
lord,
contest-
even my lord, in page number 11, it can be taken, my lord. The schedule which had they set out, my lord. What the it's a RT shed brick built room.
All right. Yes, Mr. Mukherjee.
Why
Yes,
commercial?
yes.
Why commercial? I'm telling because because he is using, partly he is occupying as using the driver's residential place, and partly, my lord, all the four-wheelers. These, my lord, four-wheelers are parking. He is collecting rent month by month.
It is not in record, Mr. Mukherjee. For that, you have to then it is to go back.
I'm not from my paragraph 5
of
my objection, and
Yes.
court has considered that. I'm
Yes.
going to your lordship. Kindly see paragraph 5, page 56.
Yes.
That the suit property decretal property is situated at well-known locality at Howrah, which has a mixed occupancy, that is commercial and residential. Then it is near the railway station, that is Morigram, market, school, everything, main road nearby the location of the suit property. At the time of disposal, the
Naturally,
prevailing
at that
market value of the locality is required to be considered by the court. Now kindly see once the order. The court has considered. On consideration of the same, I find that as per the schedule of the plain, the suit property is situated at a prime location at Howrah. I have specifically stated. On the other hand, learned advocate for the respondent has submitted that the appellant has filed the instant appeal only to delay the eviction proceedings. He has further submitted that if the application for stay is allowed, then it should be subject to payment of reasonable occupation charges, as the suit property is situated at a prime location at Howrah, which has a mixed occupancy, that is commercial and residential, then near railway station such and such. We have cited some judgments. Now court, kindly see. Then on consideration of the same, I find that as per the schedule of the plaint, the suit property is situated at a prime location at Howrah. It is admitted fact both sides that the execution of the decree of the trial court would soon to be taken up. For fair adjudication of the appeal and the appeal is in continuation of the suit, it is required to stay up all further proceedings of the trial court till disposal of the appeal. Otherwise, it would cause multiplicity of judicial proceedings. Then court comes to a conclusion, 5,000, subject to payment of, considering the assessment. Kindly see, the respondent deposited the assessment valuation property in question. Your lordship is asking whether I have submitted or not. Kindly see this. The respondent deposited assessment valuation of the property in question, and also I produced that the rent is 9,000 others. Now it is not the case that only one line the court has considered. Now, if your lordship considered, he is using mixed, both residential and commercial. Now let me complete.
That my lord has not been stated in the plaint also.
Yes.
Now, my lord, kindly see. Now, my lord, we have produced document, court has considered, but my lord, I don't know why my counterpart has not challenged this, because this is only from the date of the application, not from the date of the decree. Now, kindly consider the judgment of the apex court, my lord. Aktaram, your lordship knows, my lord. The Aktaram judgment, my lord.
That is Supermax.
Yes, my Supermax. Supermax has been one by one.
Supermax considers everything. Please give me.
Mala, they have seeked out.
But kindly see this Vijay Kumar Manish. Here it has considered everything. Supermax, Aktaram, everything. 2024 volume 8 Supreme Court cases, page
Vijay
668.
Kumar, Manish Kumar.
Vijay Kumar, Manish Kumar.
That's
Then
that's
subsequently,
a different thing. In SLP, that amount which was directed to be deposited.
kindly see paragraph 23 and 27.
Push.
Supermax has been considered in that judgment. Then, my lord, subsequently, my lord,
Here, it's a Dalhousie area property.
Supermax possibly, I have to, my lord, I have not gone,
I think so.
but that has been subsequently considered in 2025 volume 4 Supreme Court cases.
Can I have the
Supermax has been considered. Supermax and Attaram, paragraph 23.
Yes, in SLP,
yes,
interrogatory applications are filed. Yes, Dalhousie area, paragraph 14.
But then kindly see paragraph
It's a
20.
different thing, Mr. Mukherjee. Here, it was due to the pendency of the
Absolutely,
suit,
absolutely.
whether occupation charges can be passed. This is not on a decree of eviction.
That has been
Here, it has been distinguished. Aftaram and others were placed. The Honorable Supreme Court has distinguished, saying that in that is against a degree of eviction.
The 2026 volume 3 Supreme Court cases. This is lifestyle liquids. But in paragraph order 41 rule 5, what is the proposition that has been considered in my lord, paragraph 66, 67 and 138.345. Blanket stay cannot be granted, my lord. And what court has done? Court has considered my their submission. I have not filed anything. Court has considered my documents. 138.3, kindly see that the proposition order 41 rule 5.
Yes.
Then 138.4 and 138.3, there must be a reason, my lord, while granting the order of stay, the determination of occupation charges. Here court has considered my document, and what amount has been fixed? 5,000 from the date of the filing of this application. Now, my lord, in subsequent judgment 2026 volume 3 701 SEPCO Electrics, my lord, this is my lord, in respect of arbitration proceedings.
This application under Article 227 of the Constitution of India is at the instance of the
Did there, schedule, my lord, the suit room.
The Honorable Supreme Court in Niaz Ahmed Khan, Supra,
Would have shown out the,
Yes.
in the plan what they have sent out of the schedule.
Yes, yes. Yes, call the next matter. একটা fixed আছে না? দুটো দুটো fixed আছে। Yes. Yes.
My lord, I am for
Yes.
the caveated husband. কোথায় গেল?
Yes, Mr. Mondol. What is your instruction?
Yes, my lord, my client is here, my lord. She is on her way, my lord. She is on her way.
Yes. You are occupying the entire property.
But since they are not there, my lord, I am enjoying the property.
My lord, without any order from the PWD.
But you have no objection if they come back.
Let my client, my lord, come, my lord. She's just making the sleep, my lord. She is on her way, my lord. She is coming.
What is your instruction? Does she have any objection or not?
She has no objection.
All
My
right.
lord, only
Yes,
one thing,
now-
my lord.
yes,
The
now proceed on
father-in-law-
merits.
Father-in-law has expired.
Yes.
Father-in-law has expired. During my lord, his lifetime, father-in-law also instituted a suit against me and against my learned friend's client. Praying for
Yes, now move
declaration
on
and
merits.
permanent injunction.
Now move on merits. Yes. Yes.
Kindly, my lord, comes to my application. My application is at page 21.
Yes.
At para 4, my lord, I have stated my expenses. My lord, I have given a chart of my expenses.
Yes.
My lord, thereafter, my lord, kindly, my lord, comes to page 24, their objection.
These are your expenses.
These are my expenses, my lord. Total expenses to be 15,000 per month, my lord.
15,000 per month.
Per month.
And what is the alimony you are getting?
6,000.
How are you maintaining these expenses? What is the source of the balance amount?
Source, my lord, from my father.
Have you stated that?
No, that is not stated, my lord.
Yes.
That is not stated.
Then no loan, nothing.
No.
But yes.
That is not.
Yes.
Hey, my lord, in my application,
You are alone or any son?
No issue, no issue. No
All
issue.
right. Yes.
No issue. Lord, they had admitted in their written objection, my lord, the income of the respondent is 30,000 per month.
Income of the respondent means their income. Yes.
Their income is
30,000 per month.
30,000 per month.
Yes.
But, my lord, kindly, my lord, comes to now, my lord, their affidavit in affidavit
No,
of assets and
please show me
yes,
the earlier order of alimony, the initial order of alimony.
page 20.
What was the finding of the income at that point of time?
Page 19, my lord.
Yes.
Page 19, my lord, OP husband filed written objection denying the allegation of the petitioner. It is alleged that the petitioner always used to pick up the quarrel with the OP, cause insult to him. He denied demanding 2 lakhs or doing a sort of physical or mental. In father, OP further alleged that his father and mother filed a maintenance case against him, being case number.
You are getting maintenance from other proceedings.
No, my lord, there was a DB case pending. Now, my lord,
Yes.
since the amount of alimony granted in this proceeding was higher, so the higher amount was being paid.
Yes. Yes. Then
the petitioner earns, my lord, by with. This is the finding, my lord. Page 19, my lord, the first para, this is the finding. And thereafter, my lord, in
what
order
is
to
the
prove,
finding of own income of the husband?
my lord, submitted documents such as salary slip and document of the Canara Bank.
So gross salary is 19,839.
That they have stated. My lord,
No, that is the finding also.
That the finding also, but
You have not challenged that.
no, that is where my case is. My lord, kindly, my lord, sees their affidavit. Their affidavit of asset that starts from page 34. In their affidavit of assets, they have stated, my lord, in page 36, my lord.
Yes.
Page 36, kindly, my lord, sees serial number 10.
Page 36, serial number
10. Serial number 10,
Yes.
my lord. Copies of bank statement attached herewith. My lord, my counterpart has checked it. My lord, no copies of the bank statement has been filed with the affidavit of assets.
Yes.
My lord, moral. And also, my lord, they state, my lord, they are, my lord, the opposite party is employed in the government of West Bengal and his designation is as upper division clerk. Now, my lord, no salary slip was also attached with this affidavit. But that salary slip was produced by us before the learned trial court. That
Yes.
salary slip has been attached, my lord, here page 46.
Page
46.
46.
46 is the salary slip. And my lord sees the earnings. Grand total is 47,580. Now, my lord, there is statutory deduction 2,740. Now, my lord, out of account deduction is 10,415. Thereafter, its net pay is coming 34,425.
Yes.
And my lord,
Yes.
my up to July, my lord, my area statement is given in page 45. Page 45 is the statement of the arrears.
Yes.
As up till July, it is 60,000.
Up till July, it is
60,000.
no June.
No.
This is June 2026.
June. Sorry.
It's 60,000.
June up to June 2026 is 60,000. Now,
Yes.
kindly, my lord, sees the order impugned.
No, but it should be July because here you have said June, but in 2026 multiplication is by 7.
7, my lord. Yes. That would be July, my lord.
Yes.
That would be July.
But in the end, you have said June.
Yes.
Yes. Yes. Then.
My lord, kindly, my lord, comes to the impugned order.
Yes.
Let's see. Further, the case of the husband is that the salary of the husband is not rupees 50,000 per month, and he does not use to draw rupees 30,000 per month approx as salary.
Which page? Which page?
Not the second page.
Yes.
Not the second page, my lord. Third paragraph. The case of the husband is that the salary of the husband is not 50,000 per month. He does not draw rupees 30,000 per month approx as salary after statutory deduction. Moreover, his parents have been residing in a rented house as the wife drove them away in the residence and took control of the entire residence. Further, the case of the husband is that he has to pay rupees 4,000 per month. He has also electricity of that rented house. He has to bear expenses of his parents. His parents are completely dependent upon his income. He has to pay rupees 2,000 per month for medicine of his parents. Further, the specific case of the husband is that he is now residing in a rented house as to pay rupees 3,000 per month and rupees 700 on average basis of electricity bill. It is pleaded on behalf of the husband that the wife is a servicewoman, earns handsome amount per month as salary, but she hides this case before this court to claim maintenance from the husband. Moreover, the wife filed so many cases against the husband, and for the reasons he has to pay considerable amount per month as the court expenses from his salary. In support of their rival contention.
How many proceedings you have initiated?
Not only, my lord, the domestic violence and this proceeding. This proceeding is filed by the husband.
What proceeding?
This divorce.
Miscase you have filed.
Miscase I have filed. Miscase I have filed.
And other proceedings?
Got domestic violence, my lord.
There is no other proceedings. 498A?
498. Lord, pending.
20,000
That is not pending. That was filed, my lord. That is not pending.
But that was filed.
That was
Initiated.
filed. That was filed.
Any other proceedings?
Lord, that's a title suit, my lord, is pending, my lord.
For what?
This is the plaintiff, my lord.
For what? For what?
For my lord, the father-in-law has filed against me and my learned friend's client, praying for declaration of the property.
Yes. Yes. Then
Then Milord, Milord comes to next page, Milord.
yes.
At the time of hearing, the salary slip of the husband has been produced, from which it appears that his gross salary is rupees 47,580 and the net salary is of rupees 34,425 for the month of November 2025. Lord, thereafter copies. Now, Milord, has been rightly contended by the learned senior counsel for the husband that the wife has shown her monthly expenses as rupees 15,000 and or rupees 20,000. She is getting only 6,000 per month as monthly maintenance. And if that be so, how she has been spending rupees 15,000 or 20,000 per month? That further means that she has certainly some other source. Admittedly, wife is in exclusive possession of the entire residential building. After Milord, the description of the building is there.
Yes.
Certainly,
There
sir,
is areas of 60,000.
Well, area is of only 20,000 to my instruction, because I have the entire receipts that I am paying on daily basis, well, on regular basis. To my calculation, it is 20,000, that is area.
Please give your calculation to him because his calculation is at page 45.
Milord, kindly Milord, sees the last page of the order. Milord, no adjudication with regard to that. My application for enhancement has been rejected. Thereafter, today the petitioner
Yes,
has
yes. Please give your calculation to him.
My lord.
Please give it to him. Let him ascertain.
My lord, one more thing. If you
So according to you, 20,000 is
20,000 is
Have
due.
you paid 20,000?
No, my lord. It
Why?
is. No, my lord, that is the area.
When can you pay this 20,000?
My lord, within 7 days.
Yes.
My lord, one more thing, if your lordship kindly sees. My lord, page 27.
Please pay the area amount, admitted area amount.
Yes.
Ashun. Mr.
784.
Hard.
Let page 27. My lord, the affidavit of asset that they have annexed.
That I will consider. Please first liquidate the area amount, admitted area amount.
And there
please
is.
take instructions on page 45. Mr. Mundal, you please also take instructions as to what.
My lord, page 45. Page 45. Oh, acha, ota. And my lord, there is earlier an order of this honorable court. My lord, this is the order of this honorable court to conclude the proceeding by end of September. My lord, that has also.
That will be concluded. Yes. But please first pay that. Yes.
Well, this time is going to expire by September 2026.
Cannot, have to stay
Yeah.
because there is an admitted areas.
Admitted area.
Then
Well, I will be paying by this with
you
1
will
week.
keep the area spending of alimony and say it will be expedited. This has to be stayed on that ground.
My lord, I will be. As you know.
Yes, next.
Grateful to your lordships.
Put it up, man.
এই ওটা আমাদেরই ছিল।
Yes.
But I am for the petitioner.
Yes.
First of all, my lord, there is the concurrent finding, my lord. We have lose the case, my lord. Thereafter, my
Who
lord,
are you?
I am the, my lord, I am the, my lord,
Preemptor or preemptee?
I am the, my lord, PMT.
Preemptee.
Please, lordship.
Preemption application was allowed by both the courts.
Both the courts.
Yes. What is the ground of challenge?
Challenge is, lordship, there is such documents, my lord, which is not in the record. But, my lord, the first ground is, my lord, the deed was executed of 10/7/2007.
Deed was executed
Deed was executed
on
10/7/2007.
10/7/2007.
And
Yes.
this suit was filed, lordship. This is the full. And
Suit
the
was filed on
29/11/2007. There is a delay, lordship, 4 months, 2 days.
4 months, 2 days.
4 months, 2 days.
How can it be? What is the period of limitation?
Lord, the period of
This
limitation is
preemption on what
as,
ground?
as per section 11.
Preemption on what ground?
Preemptions, lordship, lordship will find the page 27 is the, my lord.
Please show me the finding on limitation. Please show me the finding on limitation by the.
There is no such, my lord, finding as such, my lord, beyond the record, beyond the, my lord, without considering the limitation ground, and, my lord, the other ground also. I am the, my lord, the entire share has been transferred to us, my lord.
Entire share.
Entire share, lordship.
It's not. Exhibit 5, this is a part of record. I am reading it. I am reading it. Exhibit 5, page 42
Page 42 of the.
of their civil division petition.
Yes. Page 42, yes.
Page here.
This is the deed.
This is the deed, schedule.
Yes.
Out of 40 decimal, 3 points or something. He says entire.
All right, please show me the finding of the appellate court on the limitation point. Where is the trial court's judgment?
Trial court judgment, the lordship, subsequently it was separated phase. Lordship, they have, my lord, we have challenged only on the point, my lord, there is lack of. Subsequently, my learned senior friend has submitted before your lordship is a separate phase. Lordship will find.
Yes,
Lordship, page 23 is my memo.
everything has been decided. Point of limitation also decided. It has been said that it's a portion of a plot which has been transferred. So these are your 2 points. Anything more?
Lordship, Lordship, kindly find page 29. Lord, this is the my lord operating this is the finding of the court, my lord.
Yes, when the registration was completed.
Registration was completed 10/7/2007.
No, no,
Registration was no in 2015, sir.
29/6/2015.
Sir, I have read. I can give you the dates. 2015 it was registered. Limitation was an issue, it was decided.
Lordship, kindly come page 29. Lord, this is the finding of the
Trial court.
learned court below, my lord.
Yes, yes.
OP did not take part in the argument.
Yes.
Not only that no evidence adduced from the part of the OP, more the on perusal of the case record and evidences record, I do not find anything to hold their instant proceedings is not maintainable in the present form. My lord, this is I am not properly placed my case.
That's for you. You have not appeared. You have not adduced any evidence. It's for you. You have chosen not to do that. Next, you can proceed thereafter. Limitation finding is thereafter. Please see on perusal of the alleged deed of transfer, Exhibit 5. It reveals that the registration of the deed was completed on 29th of June 2015. That is during the pendency of the suit. And the limitation starts when the deed is registered in the book volume. So that's the starting point. It was done during the pendency of the suit. So how can it be a limitation? Any other point?
Lordship, the page 13. This is the, my lord. This is the, my lord, plaint. My lord, seller is not a party of this, my lord.
Vendor is he a
Vendor is
necessary party? Do you have a judgment on that the vendor is a necessary party in a preemption application?
In you
have a judgment. Contrary judgments are there. Have you brought any of the judgments in your favor? Vendor is a necessary party in a preemption application under Section 8. Please show me one judgment.
But my submission.
There are many
different-
judgments
Lordship,
against
Lordship.
that. Please show me one which is in favor of that.
I have to bring, my lord. I have to bring, my lord. There are certain judgment against me and certain judgment in favor of the lord.
Please give me one judgment which says the vendor is a necessary party in an application under section. At least I have not come across one judgment of that. If you have got many, please give me one.
But the initiation of the this plaint and subsequently pass the order from the learned trial court, my lord, I have no opportunity, my lord, to place my case, my lord.
You did not. You chose not to adduce evidence. Chose not to participate in the argument. That's for you. You have taken that risk.
My lord, that is
maybe knowing the merits of your case, you have not adduced your evidence, not participated in the argument. Anything more?
Lord, see, these are the main points.
Mr. Rai, anything to submit? Yes. Heard the learned advocates for. Want to make any submission?
No. My lord has dismissed it. I have not.
I've reserved it.
Reserved it.
না বলেই তোমার হয়ে গেল রকেল ফি দেবে না মনে আছে তো
Saying
judgment.
No. What Mr. Chatterjee is saying.
Chatterjee says I will not be paid because I have not uttered a single word.
in English.
In English.
Yes.
Nowadays, everything is videographed.
Then
Probably client is watching and sees that I am spectacular.
So you want to make argument? That is what I asked you. If you want to make, you said no.
No, what argument shall I make? Lordship, everything knows. Concurring finding of both the courts, their judgment is with me. I am not citing. Because that judgment only I brought.
Now, yes. What judgment you have brought? For what?
I don't require.
Said that he has not said anything in English. That is what now he is saying. What point?
Only one the concurrent finding of both the courts cannot be interfered in 227. That judgment I wanted to, if necessary, but I will not cite it. Unnecessary. Why do I waste time? I thought my lord will dismiss just now. That's why I am.
Yes. If you want to rely upon that, please give a photocopy of that. Yes. You have a photocopy?
Relying upon that judgment, one single bench has passed a judgment.
এটাকে একটু লিখে রাখুন তো মিস্টার বিএন রায় বলে উপরে নোট অপোজিট পার্টি বলে
কিছু তো লিখতে পারবে আচ্ছা
Yes. Call the next matter.
Next call করে দিয়েছি call
Yes, Mr. Datta, what happened?
Milord, we have number one, we have got.
Yeah, Milord, because he doesn't want to infect us.
Rani knows. That's right. I hope what is happening in Delhi has not happened to me.
No, bolo na. H1N1 is a bad thing.
Now it's saying that it's a form of COVID. What is now?
Yes, absolutely.
Mild.
That's
Milord, if your lordship goes to any of the hospitals, the pulmonologists are very busy. Very busy.
yes, that is being said. I do not know that's.
It is a part of COVID. That's what I was also told. I am now very conversant with hospitals, Milord, and the way things are. They're saying.
Yes. It is which matter? Yesterday's matter.
Yes.
Yes, Mr. Datta, what is your instruction on that?
That Milord was Milord this thing Milord the NIT Milord has been issued by inadvertence. We are withdrawing it. Your lordship may record that. My lord may record.
Records.
এটা রেকর্ড করে নিন তো
But like in other ordinary proceedings, Milord, under the Eviction of Unauthorized Occupants Act, the ground of eviction was non-payment, unauthorized construction, parting with possession. These were the three grounds. But then Milord, it leads to an eviction order. To stall Milord the eviction proceeding, Milord, they go for a suit. In the suit, Milord, there was an injunction in the form of status quo as regards inter alia as regards possession.
Now thereafter, my lord, the eviction order comes. And my lord,
suit was filed pre-eviction order.
Pre-eviction order.
Yes.
Then, my lord, then eviction order, eviction takes place. My lord, in the eviction, I mean, challenging, my lord, the eviction order, my lord, a regular civil appeal is filed, not a PP appeal. Now a regular civil appeal was filed, and therefore, my lord, the learned judge, my lord, was
registered as miscellaneous appeal.
Both are registered as miscellaneous appeal.
Both means
My lord,
regular appeal is not registered as.
Look, I am told, my lord, the Order 41 Rule 1 appeals are also, my lord, numbered as misappeal in Howrah Court, subject to correction. And at the same time,
Howrah Court man has gone. Where is Mr. Tanmay Mukherjee? But Mr. Dotto, I don't think so. From the decree, it has to be a title appeal. I have not seen, subject to correction by you, any regular.
This is not an appeal from a decree.
True.
No, Mr. Dotto says any order under Order 41 Rule 1 that's been registered as miscellaneous appeal, subject to correction, I don't think you have been properly instructed on that. Because miscellaneous appeals, one is Order 43. Those appeals, those are registered as miscellaneous appeals, where here it's registered as class miscellaneous appeal. But regular appeals are not registered as miscellaneous appeals.
May I kindly have a look to this.
What is this?
But this is where the case status of this appeal.
Case stage.
Case status.
Yes, case status of case stage.
Whatever, yes. But this is the misappeal that they have filed. Now, if your lordship may kindly take the second page.
Hearing, appearance and hearing.
Please take the second page. Please turn the page.
Yes, second page.
At the top.
Yes.
Acts. Your lordship finds below the Act. Under Act, Civil Procedure Code, under Section Order 41. But kindly see the second page, this part.
Mr. Dotto, have you seen any of the presentation forms of the civil division application? In all matters, the act will be civil procedure code.
Right.
Don't be on that technicality, because might be some presentation form or like that. I am telling you in most of the matters. So it might be here also.
Yes,
where is the presentation form here? Let me check up.
Check on that case.
Yes. Subject category code, landlord-tenant dispute, landlord-tenant dispute. It's your presentation form. So I'm rejecting the civil division application, not in form.
For more reasons.
So I'm telling you, in all matters.
Here, my lord, it is not a question of, my lord, a mere misdescription. It is a case, my lord, where, my lord, if I may say with respect, my lord, it is a deliberate misrepresentation. Why? To avoid, my lord, 12 days of limitation. And the learned judge, my lord, while, my lord, admitting the appeal, have recorded, despite, my lord, the expiry of 12 days or exceeding 12 days, my lord, in preferring the appeal, records that the appeal is within time. According to our calculation, my lord, the appeal was filed on the 25th day after, my lord, the eviction order. Therefore, my lord, it ought to have.
According to you, if it's beyond 12,
yes,
it's barred by limitation.
Yes.
I think on facts, Mr. Chatterjee cannot dispute this.
Very much. But I'm not opening my mouth now. Let my learned senior friend finish. And
Yes.
Now, my lord, when the
you have not filed on the 25th day of the order passed.
Yes, yes.
That is what I'm saying. You cannot dispute on facts of this.
Sees the provision once. It's from the date of publication. Then it comes to me. So I'll get that
says
video.
From the date of the order, within 12 days, you have filed within 25th day. That's his submission.
Yes.
I've said on facts, that cannot be disputed.
No.
That is what I'm saying.
I am saying he can't even open his mouth on this. That I will say later, my lord, not.
Yes.
Now, my lord, please take me at page 45. Kindly have a look to 45.
45, yes. Yes.
Order number 1, memo of appeal filed, challenging the order of 30th of January, passed by etc. in proceeding etc. along with Wakalatnama registered the same as misappeal. Court fee is correct. Appeal filed in time. Appeal admitted, copy served, objection raised. Therefore, it was initiated or filed, my lord, as a regular civil appeal, not a PP appeal.
How PP appeals are registered?
Very important question. Let them say.
My lord, PP appeals, my lord, has to, my lord, have a nomenclature that it is under the PP Act.
Howrah Court doesn't have it.
If it doesn't have a nomenclature, assuming for argument's sake, then also my lord, the period has to be counted as 12 days for the purpose of limitation.
That is a different thing, because if it is a PP appeal, limitation is under the PP Act, that has to be considered.
Yes.
Yes, but what you are submitting, that memorandum is to be say that in the caption it has to be mentioned under.
Lord, may or
There
may
is no
not.
prescribed format, Mr.
May I will not trouble your lordship on the form. I will trouble your lordship on the substance.
Don't trouble. Yes.
So the substance is that you have to come within 12 days.
Yes.
Or else.
Yes.
Pray for
Or else
condolence.
limitation.
Yes. Now, my lord, here, my lord, either it is deliberate or, my lord, it escaped the notice of the learned judge.
Yes.
Whatever it is, but in my respectful submission, the result is that there is no appeal in law. Now comes, my lord, the next part. Please take now page 46.
46, yes.
Now here, please take, my lord, the third paragraph. Learned advocate on behalf of the court undertakes before this court that execution will not be proceeded at this stage, but prays for early hearing of the appeal. Now, this is an undertaking which is recorded. Now, the next paragraph is very important, that is the learned judge proceeding on the basis of the undertaking, or the learned judge is applying his mind. Please take the next paragraph. It appears from the impugned order that if the above mentioned payment, where it's 3 lakh and odd, is made by the appellant, the port authority will not be entitled to proceed for execution. It is the case of the appellant that the payment is made as mentioned above. Under the above facts and circumstances, no order of stay is granted at this stage.
This payment that has been made, there is no dispute that this payment has been made.
Yes. Payment has been made. There are other deals I will not.
No, but
yes.
for this, it appears that the above mentioned payment, above mentioned is 382,139.
Yes. Right.
So this 382,139 has been paid.
Yes.
There is no dispute on that.
Yes. But there are other grounds of eviction also.
No, but it
This
records
payment
this.
is made.
Yes.
This payment is made.
Yes.
Therefore, what the learned judge does, learned judge was pleased not to proceed only on the basis of the undertaking. The learned judge applies his mind that if this is paid, nothing is going to happen to them. Therefore, no stay at this stage. This is very important. So it limits it for a time. Then let the case record, etc., transfer so and so. Now, what happens there?
What is the meaning of this expression at this stage?
It has to have a time limit. Like, for example, Miller, your lordships passes interim order saying that matter be made returnable on so and so date. This interim order in the meantime. Now, this has been interpreted by our court. So at this stage, and in the meantime, in my very respectful submission, can be used, applied interchangeably. I'll demonstrate before your lordship, my lord, our court, my lord, has defined it. Our court has not defined at this stage, at least I could not find.
In the meantime,
Yes.
yes.
Now thereafter, my lord, when the matter comes up, my lord, the matter gets adjourned days in and days out, my lord. From 47 onwards, my lord, there are a host of orders, my lord, your lordship will find, my lord. My lord, the matter gets adjourned. Now there was a stay, my lord, in the suit. Kindly have a look to, my lord, the status quo in the suit at page 44.
That suit is pending.
No, it's gone. Therefore, we have taken possession. Now, this status quo was there before my lord, the eviction order was made.
Yes.
23rd of December 24. Please
It
take
was
my-
till 22nd of January 2025.
Yes,
Thereafter, no extension.
no extension.
Extension.
On the undertaking part, there is no extension.
No. Page 44, you have said that in title suit, there was an interim order for which you did not take possession.
Right. And
So
thereafter,
this interim order was valid till 22nd of January 2025. So thereafter, no extension.
but thereafter, my lord, we had used and filed an application under Order 7, Rule 11.
Yes.
That Order 7, Rule 11, my lord, was ultimately allowed on 23rd of June 2026.
But only
at page 43.
only one clarification, Mr. Dotto.
Yes, my lord.
Till the plaintiff was rejected in that suit, was the
Extended to-
interim order extended? Extended. Yes.
Now kindly take me my Order 7 being allowed at page 43.
June 2026.
Yes, it was allowed. Now, my lord, I take possession on 1st of July 2026. But this is, my lord, pleaded at my lord, paragraph 17 of my 227 application.
1st of July
2026.
Paragraph
17 of my 227 application.
71.
17.
Oh, 17.
Paragraph 17.
Paragraph 17. Yes. Date, there is no dispute, Mr. Chatterjee. Yes.
Sir, my learned friend's client, Millard, files a 151 application, Millard, in the misappeal. Whatever is the appeal.
Yes.
For praying for restoration of possession. That is, Millard, page 57. My lord, may I have a look to the prayer at page 59.
Restoration of possession.
Yes.
To unlock the padlock.
Yes.
Yes.
Then, my lord, they come up before this court under 227 for an expeditious disposal. My lord, the coordinate bench, my lord, disposes of the 227 application with a formal direction to
To
consider.
dispose of this application.
Yes.
Yes. So now the impugned order is with regard to that.
Yes. Now, my lord, the impugned order.
You file any objection to this?
ফাইল করেছিলাম 151 অবজেকশনটা বের করতো অবজেকশন আছে বলছে তো তাই আমি তো দেখিনি দেখো
Which page?
আমি কিন্তু দেখিনি তোরা বলছো
No,
I am not sure. I am not sure.
No, the order must record something.
But the order subject to correction, my lord, doesn't record.
With regard to your objection, what is the date of the order?
But the date of the order is 28th of July.
Is it the certified copy at the back? No.
That point, so I have not even said, there is no certified copy. Right, right?
But certified copy has come.
Has come.
Yes, yes.
File the certified copy, Mr.
Yes, yes.
What is the date of the impugned order?
28th of July, 2026.
Yes. Page 66.
Yes. Please
Yes.
take paragraph 2. Huh? With the para 2, the appellant alleges that in the morning on 1st of July, the agents of the respondent, defying their own undertaking and without any order of execution from this court, visited the suit property at so-and-so and broke open the padlocks and placed their own padlocks, forcibly took possession. Appellant contends that this action caused immense financial loss and disruption, etc. Then agreed by this action, the appellant has filed the present application under 151. But the submission of the appellant is there. Then please take me note our submission at paragraph 8. Learned counsel for the respondent challenged the maintainability of the application, submitting it is an abuse of the process of law contending inter alia that the undertaking was given only at this stage, so it is crystal clear from the undertaking itself that it was limited assurance not having the nature of perpetuity or the undertaking was not an absolute bar on execution, and since that undertaking over a month has passed and the statutory period of disposal of the appeal has lapsed and that there is no formal order of stay, as such the eviction order remain executable and an undertaking cannot be read in isolation to create a substantive right beyond what the court had expressly recorded. And furthermore, as the tenancy of the appellant was terminated in 2011, they are an authorized occupant and the Port Authority has the right to take possession. Now, finding of the court. The core issue for determination is the legal effect of the undertaking given by the respondent to the court. The undertaking of the respondent was clear, execution will not be proceeded with at this stage. This was not a casual statement but a solemn promise made to the court on the basis of which the court proceeded. Learned district judge did not pass a stay order precisely because of this undertaking. The court placed its faith in the commitment of the respondent. The respondent was bound by this undertaking as an officer of the court. It is a fundamental principle that courts rely upon the undertakings and any breach thereof undermines the administration of justice. The respondent has argued that the undertaking was time-bound at this stage. While it is true that the undertaking did not have the effect of perpetuality, the phrase at this stage in the context of the order refers to the pendency of the appeal proceeding. This possibly, my lord, your lordship has to consider whether this is a correct interpretation or not.
At this stage?
At this stage. The appeal was admitted and pending before this court, the court relying upon the undertaking passed the order, meaning thereby that the respondent was not to proceed with execution until further orders from the court or until the appeal was disposed of. If it is interpreted otherwise, it would render the undertaking meaningless and undermine the judicial process, having induced the court to withhold a formal stay order based on its promise. The respondent is restored from acting contrary to it. Then where paragraph 13 says that we did not seek leave of the court.
So according to you,
yes,
this interpretation,
yes,
that at this stage, which has been interpreted by the appellate court to mean during the pendency of the appeal, that's not the correct interpretation.
Yes, that would be my submission.
Because that's the foundation of the order.
Right.
So, and the court records that an undertaking was given, there was a breach of an undertaking, and you have taken possession by breaking open the padlocks, could not have done so in that way. You could have approached the court, taken permission and other things. That's the finding of the appellate court.
Right. But in respect of the order, my lord, I have got twofold submission. My first submission I have already made, that, my lord, the court did not proceed on the basis of the undertaking simpliciter. The court had applied his mind, and, my lord, was of the view that no stay should be granted. Because according to the court, payment of 3 lakh and odd
was sufficient to resist the execution of the eviction order.
Yes. Yes.
Number two is, my lord, at this stage.
Yes.
But this is not in respect of the order.
Yes. What is the submission with regard to at this stage? Any authority you want to?
Yes. My lord, your lordship may kindly take, my lord, two judgments. One is of our court, the other is of the Supreme Court. The 92 supplementary two, 1992 supplementary two. Yeah, we'll get a copy. বলছে আদার সাইডকে দিলে আদার সাইড খুশি হবে আমার রকম 92 supplementary to SCC 644. But please take my paragraph 11 and 12.
Paragraph 11 and 12.
Yes, but this arises, my lord, from a anti-defection proceeding. A hot topic now. Number 3, who was elected under and for the purpose of proviso to paragraph 6 of the 10th schedule asserts that the writ petition and that the order did not bind him. See, Sharma, his learned counsel, however, contains that even assuming that the respondent could be attributed with the knowledge, of this order, the order cannot be held to survive beyond 30th of October 1990. Sharma urges that the expression in the meantime limits in point of time the operation of the order only till so and so, and that in all event that order was not passed for the benefit of the or at the instance of the appellant to entitle him to take advantage. The question is question as to what is the outer terminal point of the operation of the restraint when the expression in the meantime is used is arguable. That expression takes its color from the context. There are words of relation and refer not only to a time that is to begin, but to a time which is also to end. It is difficult to say that the period of restraint spilled over 30th of October 1990 and the restraint on altering the status quo continued. The order was not made either at the instance nor for the benefit of the appellant. In the facts of the case, we do not think we are justified in construing the status quo order to continue to operate even after 30th of October 1990, or even if it did, it inure to the benefit of the appellant.
What is October 30, 19?
Because the matter was made returnable on 30th of October.
Where is that? Which
yes,
paragraph?
That's what I'm trying to find out.
Oh, yes. Paragraph 10, that italics portion.
Yes, italics, yes. In the meantime, status quo continue. As on today, will continue.
So it has to be looked into in the context of that matter.
Yes.
So it's not a straitjacket formula.
Yes. Now here, I would be very respectfully submitting at this stage, in the context of this matter, is that I am not going to pass any order of status quo till the returnable date. I am not passing an order of stay. The Miller words of the order is very important. With an undertaking, your lordships may stay an order. With an undertaking, your lordship may say, don't proceed with the matter. Similarly, with an undertaking, your lordship may also apply your lordship's mind and say that I'm not going to pass any interim order.
Yes.
Now, there is another judgment of Justice Pal, Justice Uma Pal. Kindly have a look to this. Asni? Please take away the first paragraph and paragraph 12E.
Yes. Paragraph
12A. देखो ना, देखो ना.
No, no, no. না তোর এর মতো কন্টেন্ট ক্লিয়ার হতে কন্ডিশনস কন্ডিশন হলে হবে না তারপর প্যারাগ্রাফ 8 এর একটা
Therefore, my lord, my respectful submission would be
পাশের নামটা দেখি ডাক্তার মানে ওরা একসাথে বসেছিল রুমা পালে জাজমেন্ট বাবাও ছিল সেরকম judge together.
Yes, yes.
Same day.
That is what I was thinking.
90 they became judge.
Yes. This is order passed in 1991 April.
Very clear. But this judgment I knew, but I didn't realize it was.
Within 1 year,
Yes.
division bench.
No, I think
Must have been in some peculiar circumstance.
I think this is a contempt.
Must be the earlier. Judging.
Must be in a division bench of something. One that might be. Yes. Mr. Nag, please give me a
Yes, yes,
photocopy of that.
before the hearing.
Yes. So here,
It was heard by KM Yusuf. See paragraph 3. Haja Mohammad Yusuf.
no, that was a single bench.
Yes. And then it was taken.
Then there was a division bench also.
Vacation bench. And it said during the holidays.
Oh, another division bench presided over by Justice B.C. Boshak J.
Ah,
That must be one of them, must be of
Justice Rumapal. Justice Boshak and Justice Rumapal, and then.
after retirement, this was the constitution.
ওই সময় এর সাথে বসছে। না জাজমেন্টটা হয়েছিল হচ্ছিল বসাক
A party in that division bench after retirement of Justice Yusuf, this bench was constituted.
Yes.
Yes.
Now, my lord, these are, my lord, my twofold submission, my lord, on the order. Now, in respect of the proceedings, my lord, I've got a few submissions. Number one, my lord, I've already my lord, submitted that this is not an appeal, my lord, under the PP Act.
এটাকে দিয়ে দিন। Because it was barred by limitation.
Yes. Now, my lord, your lordship considers, my lord, whether
একটা কোথায় গেল? What is the period of limitation?
12 days.
from the date of publication.
What is the method of publication?
এটা কি গেজেটে দেয়? গেজেটে পাবলিশ করে? Rules, I don't think is there, but here the practice.
What is the meaning of publication?
My lord, here, my lord,
One
I
is
have to-
passing,
Yes.
another is publication.
Not even on that. I am saying your lordship need not get into. This is what is publication, how it's done. These are questions of fact which are not before your lordship. Let my learned senior friend finish, my lord. I'll.
Because an interesting thing in subsection 2 A, B, C, you will be finding
This.
period is same, but the starting point is different in different cases. First is from the publication of the order. B says from the date on which the order is communicated to the appellant. C says from the date of such order. So appeals period of limitation in 3 cases, starting point is different.
Right.
So it must be the legislature intended something why starting point is different under 3 circumstances.
Here, my lord, the learned judge did not undertake that exercise that it is within 12 days of its publication. Therefore, it is within time. This my lord, exercise has not been undertaken, but my lord, on the dates, so far as the dates are concerned, my lord, there is no dispute. So, my lord, this is a dead appeal, number one. Number two is, my lord, there. Number two is, my lord, there cannot be any deemed condonation.
Judgment.
The judgment again.
I
Justice Pal's, my lord, judgment.
Question on deemed condonation.
Yes, yes. Deemed condonation is if there is delay, there has to be condonation.
Yes, yes.
There cannot be deemed. That's I don't think Mr. Chatterjee will dispute that. Yes, because even if there is, though there are stray judgments, one or two that on a oral prayer it can be condoned. But even then, there has to be something. Prayer has to be made, and there's an express order condoning that.
But my lord, the most of the judgments say that limitation
application.
cannot be condoned orally. Stay can be prayed orally.
Yes, but there is one or two judgments which says,
But all-
but whatever it might be, there has to be a prayer and there has to be an order.
Right.
So not deemed.
Yes. There's no prayer, no order. Rather, the court says that no, it is within limitation. The next aspect of the matter which would require your lordship's consideration, assuming, my lord, that the court proceeded on the basis of the undertaking, assuming for argument's sake, then also, my lord, what is the legal effect, my lord, of an undertaking in a dead appeal, which vitally affects the legal rights of a litigant? My respectful submission would be it does not have any binding legal effect.
Yes.
Again, my lord, assuming for argument's sake that the undertaking given and proceeded on the basis of undertaking, please have a look to at one judgment of 1976. 1976 one Supreme Court cases 311. But I will not blame Miller, the learned counsel, but the effect is 76 1 SCC 311. But any undertaking given, Miller, in ignorance of legal rights, Miller, does not bind the maker also. So this was a case, Miller, where Miller an undertaking was given, Miller, for appearing in an examination, subject to Miller producing Miller the passing of in another examination. Please have a look to Miller, paragraph number. This was for appearing in an LLB examination.
Paragraph 3.
Yes. But finally, my lord, the conclusion is paragraph number 9.
Yes.
Mr. Nundi, counsel for the respondent, placed great reliance on the letter written by the appellant to the respondent, where he undertook to file the requisite permission or to abide by any other order that may be passed by the university authorities. This letter was obviously written because the appellant was very anxious to appear in the Part 2 examination, and the letter was written in terrorem and in complete ignorance of his legal rights. The appellant did not know that there was any provision in the university statute which required that he should obtain the permission of his superior officers. But as the respondent was bent upon prohibiting him from taking the examination, he had no alternative but to write a letter per force. It is well settled that any admission made in ignorance of legal rights or under duress cannot bind the maker of the admission. In these circumstances, we are clearly of the opinion that the letter written by the appellant does not.
Your case is not that of duress.
True.
Your case is also not that you are not
right.
aware of your legal rights.
But it is my legal right, Willard, which I have a right as an institution to have a summary proceeding, get an order if I get, and then execute it through the
Only
due
one
process.
thing, Mr. Doctor, there is a provision for passing an order of stay in such an appeal. Now, stay or an interim order, whatever it might be, may be conditional, may be unconditional. So here you may say, in this case, condition was also satisfied. that amount was deposited. So if the condition was satisfied, in that light, how do you treat your undertaking?
Milord, your lordship may.
Not undertaking given out of the way.
Yes.
Condition that could have been imposed without the undertaking.
Yes.
Without the undertaking, what should be? A
Milord,
stay would be granted subject to condition.
yes.
Condition is of deposit of the money.
Yes. No. That was not the only condition. Milord, please kindly take page
No,
41.
that is the order. The court says
Yes.
if the
Or
that-
the monetary aspect.
yes,
Definitely
only
on
the
the
monetary aspect.
Now kindly
The
take.
monetary aspect, court said
Yes.
that yes, if provided they deposit and they have deposited.
Yes.
So what the condition was in the mind of the court, that was fulfilled, that was satisfied.
Yes.
So what was left more to be done by the appellant or being favored with an order of stay or the interim order, whatever it might be.
Milord, at the beginning, where I said there were 3 grounds for eviction. Please have a look to Milord, the final conclusion at page 41. Whether giving of money simpliciter could resist execution of an order of eviction. Kindly have a look to this.
Other parts are protection. Stay is in an effect in all matters. If you consider ordinary cases of decrees where appeals are filed, some condition in some form, that is, let us consider an eviction decree passed on the ground of reasonable requirement, subletting and other thing. There is no default ground, let us assume. So in appeals against those also, so it's a decree for eviction, reasonable requirement, subletting, all things are there. Please put it in that line. But there is no default. Even in those cases, condition imposed is, what's the condition? What is the idea, object behind this fixing of this condition is that you have suffered a decree. The decree holder or the person who has got the decree is entitled to get possession right now when the decree has been passed. Now, because of an appeal being preferred by the other side, this procedure, this taking over possession, that's been delayed or been postponed to some extent. Now, for that, the decree holder or the person who has got this order of eviction, he will suffer. He will suffer in what? In monetary terms. Because what he will do? Technically, if you say that, yes, you can take possession by executing that decree, he will let it out to others. So, and he will be getting money. So what you are being deprived of is that monetary consideration. Right. So protection is with regard to monetary consideration.
Here the same.
Here is that.
Here the same thing has happened. Please have a look to the last paragraph of page 41.
Yes.
But this is part of the eviction order.
Yes.
But I'll take your lordship to the other part of the order, but apropos what is fallen from the court, please look at the last paragraph.
Yes.
My considered view that a sum of rupees 3 lakh and odd for the period from 1st November 2001 to 10th February 2011, both days inclusive, is due and recoverable from the OP by the port on account of rental dues.
Yes.
And the OP must have to pay the rental dues to so-and-so on or before so-and-so. Such dues attract compound interest of 7.5% per annum, which is the current rate of interest as per the interest charge as gathered from the website of the State Bank from the date of incurrence of the liability till the liquidation of the same, as per the adjustment of payments, if any, made so far by the OP in terms of so-and-so's books of accounts. So this is one of the part. Now this compliance of this, in my very respectful submission, has 2 parts. One is where the interest component will be looked into later on, but fundamentally this is the due. But this is not the only ground on which the eviction order is passed.
Yes, I accept.
Yes.
There is no dispute that it's only on the ground of default.
Right.
But the thing, protection is your sufferance in not getting physical possession now. Your sufferance is monetary consideration, because if you let out, you'll be getting money, rental compensation. So monetary compensation is that which you will suffer because of the postponement of the taking over of possession.
Right. Therefore, again, my lord, as the Supreme Court says in the context. Now, the context is that this payment of 3 lakh and odd is not, my lord, is as a condition given by the court. It is a condition which is there in the eviction order itself. Therefore, my lord, the court possibly, I would try to read the mind of the court, that the court did not proceed on the basis of the undertaking alone. Now, my lord, so far as, my lord, the other parts are concerned, my respectful submission is, if it is a dead appeal, why are we discussing so much? Then, my lord, 151 also will not apply.
I could not follow this.
Yes.
Last submission of
My last submission is, if it is a dead appeal.
Oh, dead appeal, yes.
Then undertaking, the validity of that undertaking, the tenure of that undertaking.
Dead appeal, nothing
remains.
There will be nothing will have any effect. If it's a dead appeal.
Yes, yes. Now comes the question of 151.
Yes.
Now 151, my lord, the same argument will follow that if, in a dead appeal, my lord, 151 cannot also apply.
Yes. If it is a dead appeal, Mr. Dotto, nothing. He cannot get any benefit. None of you can get any benefit out of that.
Well, either today, my lord, either I survive on my point of the appeal surviving or not. I would respectfully submit that there was no appeal. Then, my lord, the question is that in 151, what is the order? In 151, the order is that restore possession. May I please consider, my lord, one who is not in possession, legally not in possession, because he was, my lord, according to us, he was not removed because a status quo was ordered as regards possession was there, my lord, in the suit. The moment the status quo order went, my lord, we thought that we have the right to take over possession. We have
effect of, yes, that's one effect of this 151
yes,
is to restore status quo ante. Is to restore status quo ante, because the position as on the date of filing of this appeal, that position is to be restored. Anything done in the meantime, that's the object of this 151 order. So as on the date of filing of the appeal, Mr. Chatterjee's client was in possession. That's no dispute with regard to that. Whether on the strength of an order of the suit or otherwise, fact remains he was in possession. Now, according to you, there was no impediment upon you to take possession because there was nothing. It was a dead appeal. That order stood vacated. No undertaking, no stay order, whatever it might be. You have taken possession. So now, this 151 order is to restore back, because the appellate court might have thought, no, this should not have been done during the pendency of the suit. The status quo which was prevailing as on the filing of the appeal, that should be directed to be restored. So this is an order.
Now, then the question would arise, which court would restore the status quo ante?
Which court meaning?
Possibly, your lordship will kindly consider one thing. My lord, I have not taken over possession in violation of the order passed in the so-called appeal, whether it is PP appeal or other civil appeal. My case was that the status quo order over there has gone, therefore I have taken possession.
Where is your case that made out?
But that is the sequence.
No. Please show me that you have made out a case. Because 151, their positive case is that, what is their case? Let us take their 151 application.
Please take me their 151 application. It starts from page 57.
Yes, their case, the specific case is of violation of an undertaking in the miscellaneous appeal.
Yes.
So if you say no, show me that you have controverted this. No, I have not taken pursuant to this violation of that undertaking. I have taken since I did not take, because there was a status quo order or an interim order in the suit that has vacated, where is that case made out?
My lord, paragraph 17 at page 8.
Mr. Dotto, that's revision you cannot make out a case because this statement was not there before the appellate court. No, no, this is a case which you are trying to make out in the civil division.
Please give me a moment.
There was no objection filed. Let him be sure on.
Just give me a moment.
Because this is because this is not an original proceeding, Mr. Dotto.
Right.
If it was a 226, yes, it was a different thing altogether. 227, how can you say make out a new case? Because these statements were not before the appellate court when this order was passed.
Ordered record or
হ্যাঁ সেটাই
Without Dotto,
Yes, sir.
your submission as recorded also do not state that fact. Nothing with regard to that status quo and the suit. That was not also your submission.
my lord is making my job way simpler. These were my submissions.
আছে ফাইলটা রাখিস না কেন সবাই তোর কাছেও নেই?
বলবে
দেখ খালি ওইটুকুই দেখি তো, যদি অবজেকশন দেওয়া থাকে।
আমি ধরে নিচ্ছি অবজেকশন দিয়েছ।
I'll not allow my learned friend's client to take out anything from there because I have a statutory lien over whatever is there in the premises. He cannot take out anything. Normal documents he can always take out, like tax accounts, etc. না, জামা কাপড় তো জামা কাপড় নিয়ে আমি কত হ্যাঁ ওতেও যদি চেনা না পাওয়া যায় আপনি নিতে পারেন। এই দে তাড়াতাড়ি দে।
হয়ে গেছে?
Anything more, Mr. Dotto?
No, no, but if in the meantime it comes, I do not know whether I can
But
find out.
written objection, two things. Even if there is a written objection, but your submissions, your case is what is point which you have made. So even if you have taken something other in the written objection, not placed or pressed in whatever language it is, cannot go into that because
I will not make peace alone. I'll take 10 minutes of my lord's time. My lord, your lordship has seen mostly. There's one very important thing that I need to answer, my lord, is the period of limitation.
yes, limitation part is the, I think, is
That
the
is what
trump
it is
card of
on,
Mr. Dotto.
Is
It
trump
says,
card. Right. My lord, there are two things to that. The first part is, my lord, just give me. So what's a party? That turns to section 5 of the provision.
5 of the
Act.
PP Act.
Yes.
Yes.
Kindly have a look at 1. If after considering, Milord, your lordship may skip that over because that's not important. Premises shall be vacated on such date as may be specified in the order, but not later than 15 days from the date of the order, by all persons who may be in occupation thereof or any part thereof, and cause a copy of the order to be affixed. Your lordship wanted to know, my lord, what is publication? Affixed on the outer door of some other conspicuous part of the public premises. Proviso is not important. 5.2 is important. If any person refuses or fails to comply with the order of eviction on or before the date specified in the said order, or within 15 days of the date of its publication under subsection 1. So what
So
is
this is publication.
Affixation. So this is a question of fact. Now, why I say, my lord, this is a question of fact, now comes back to the first order. The order says it's within time, good, bad, indifferent. That order was never challenged. Even today, it's not challenged before your lordship. It is a disputed question of fact, my lord, whether it was affixed or not affixed. It has to go back to that court and say that this is the period of limitation, this was affixed on that particular day, and it was not adhered to. There is nothing on record before your lordship, my lord.
Subsection 1 do not use the word publication,
It's
but it's clarified in 2. So according to you, this affixation
means that
publication.
and it is from then that the 12 days start. So they will have to show before your lordship, my lord, that it was affixed on that particular date. দেখাতে পারবি না তো দেখাস না। চুপ। Now, my lord, this question of fact was never brought to the notice of the appellate court. And the court, good, bad, indifferent, comes to a finding, my lord, that this is within time. If the order is wrong, that order needs to be challenged by saying that there was affixation within that period which, my lord, I had filed the appeal. Simple answer, my lord, to my learned senior friends' arguments on, my lord, dead appeal. Then comes to, my lord, if your lordship sees the nomenclature of the revision application, sees what they've challenged. So it's drafted as a writ petition, but I'm taking it, my lord, as a revision application. Records and proceedings of misappeal number such and such, it's illegal initiation. This is not a writ court. And continuation and challenge to the order number 18 dated 28th of July 2026. So the problem is initiation. That initiation, my lord, is by way of an order. That order is not under challenge. It's not under challenge. Now, once it's a civil order which has been passed, good, bad, indifferent, my lord, it is an order which says it's within time. If there is an order, my lord, which would have been silent, I would have still understood. But it's a judicial order which says it's within time. It might be a wrong order. A judge is entitled to pass a wrong order. 64 Supreme Court. If you are aggrieved by that, you need to challenge it. This is not like, my lord, an authority passing an order. This is a civil proceeding order. This is an order in a regular appeal. So once that order has been passed and it's not been challenged, my lord, it attains finality. Number one. Even today, my lord, in this revisional application, they have not challenged that order. And why I'm saying, my lord, why I said 5 and 5.1 and 5.2, it is only because of what I feel, my lord, is publication. This is a dispute which needed to be, my lord, brought up before the court and which could have been, my lord, adjudicated upon.
Yes.
Now, your lordship pointed out, my lord. Your lordship pointed out about the difference between 5A, 5B, and 5C. Different times, different things. So for us, obviously, my lord, it's 5A.
A.
A.
9A. 9 to A.
Yes, my lord, 9-2. So we fall under that 5-1 category. So this had to be, my lord, in my respectful submission, brought forward before the appellate court itself. That's the answer, my lord, in my respectful submission to my learned senior friend's argument on dead appeal. Secondly, nomenclature is not a detrimental thing. That I don't need to, my lord, even show judgments on that. That's a well-established principle of law. My lord, I am told, I have taken instructions. In Howrah Court, there is no code as PP appeal. All appeals, my lord, which are filed, my lord, the order is under challenge is that Section 5 order. It's no other order, my lord, is under challenge. So my learned senior friend can't say that some other order is under challenge. Whether I file it under Order 41, whether I file it under landlord tenant as they have classified, it's not for, my lord, for the litigant to know. It's the court could have rectified it. Because the court has again said, admit it and register it as a misappeal. That's because, my lord, if I'm not mistaken, my lord, your lordship may take information we've taken. There is no nomenclature as PP appeal. In Alipur Court, there is.
Yes, it's registered as PP appeal.
PP appeal. In Howrah Court, there is none. Because even we tried, my lord, looking into the website, there also, my lord, the case status, my lord, we did not file the PP appeal. Might be a procedural irregularity, doesn't mean my appeal is not maintained. My appeal is maintained. এটা কোথায়? আবার see. They want me to show, I don't want to. But since they want to, your lordship sees it. Sees paragraph 9 once.
9 of the?
Of the revision application.
Yes.
Have a look at paragraph 10. This is what they've said. Paragraph page 5, para 10. So this should not have been even argued by my learned senior friend, my lord. But whatever it is, since my learned senior friend has said so, this is this. The appeal is under section.
So they admit that it's filed under section 9.
This trying to confuse your lordship with that title suit and this section 9 is an art.
For settling, Mr. Dotto was not consulted.
No, I don't.
আগে থেকে no আমি না। So now, my lord, this was a non-starter. So whatever it is, it's there. The second question, my lord, comes. My learned senior friend says, at this stage, what is a stage in an appeal? May I ask this question to myself? There are very few stages in an appeal. There are very many stages in a suit. In an appeal, my lord, there is no evidence. The interlocutory orders come to an end, and then it goes below to the final hearing. If an application is filed in the meantime, I can understand. But there are no stages in an appeal. What my learned senior friend wants to tell your lordship is, in the meantime, sees what the Supreme Court says. It says it restricts time.
It's in the context.
Absolutely.
So you have to see what's the context. In both these judgments, what was there on a day, on a particular day, the matter is returnable on a particular day.
And then
in the meantime, so the interpretation is, it would be within this next date of appearance.
It
I
says,
think both the judgments proceeds on the same line.
Sees the difference here. In the meantime is that there is a specific time. Like today, my lord, your lordship makes it returnable on the next day on
And in the meantime, so it is till that date.
And at this stage, my lord, is very different. At this stage is that I am standing in this stage. I am saying that I will not proceed with execution. My lord, if your lordship sees the entire gamut, this is why, my lord, Mr. Raichodri never believed in undertakings.
Yes.
Remembers, my lord, what happened to him with Mr. Dashgupta. So they should never be taken into on the shoulders of a lawyer. My learned senior friend said very lightly, but he said, I'm not I am not
Blaming the
blaming the advocate.
Yes.
I'm not blaming the advocate. But what was there in the judgment which he cited, the judgment was, beloved, a lawyer, yes, a would-be lawyer was asked to sign something which he could not have signed, and then said, since you have signed, you will not be eligible. That is in that context, beloved, that judgment was passed. In here, beloved, it is within the rights of the court to pass an order of stay. I am saying I am not passing an order of stay. Why? Because you are giving an undertaking, I will not proceed with execution. Supreme Court says, beloved, it should not stop at contempt. Supreme Court says you will have to put it back to where it was. Just have a look at this judgment. I'm not going to trouble your lordship much. I'll not even read it for your lordship. Beloved. This is 1996 4 SCC 622. Kindly have a look at paragraph 17, 19 and 21.
1996 4 SCC page
22. বের করে নে, তোর ওটা কি দেখতে? 17, 19 and 21. আমার কাছে নেই, নাহলে দিয়ে দিতাম। আছে? না, এটা হচ্ছে রেড্ডি আর পারিপুর। पूर्ण। তোর কাছে কপি আছে? हाँ? एक ही है। ये उनको दो, हमको जरूरत कॉपी नहीं। एक ही होने से हमारा kindly seize below on the left hand side 96 4 SCC 622 17 19 and 21. Supreme Court says below that you should not only purge him for put him on contempt but also put the clock back. And this was on undertaking.
This is from Madras. Parent judgment, I think, is from Madras.
Probably, below, if I'm not mistaken. If I'm not mistaken. It is key.
Oh, this is from Delhi High Court.
I'm sorry.
But there's one judgment of the Madras High Court.
Hello. There were plenty earlier, my lord. But they just found it out, my lord, just on a cursory thing. And I don't think your lordship even needs a judgment on this. This is as clear as water. My lord,
In addition to punishing the petitioners for contempt of court, appropriate directions to remedy the breach of undertaking.
Exactly. ये তোর কাছে এতে আছে ফোনে আছে उसमें दो तो दादा को दो
Yes, yes, Madras High Court, that has been referred to. In Century Flour Mills Limited, it was held by the full bench of the Madras High Court that where an act is done in violation of an order of stay or injunction, it is the duty of the court as a policy to set the wrong right and not to allow the perpetuation of the wrong.
I don't even
The inherent power of the court it was held is not only available in such a case, but it is bound to exercise it to undo the wrong in the interest of justice. That was a case where a meeting was held contrary to an order of injunction. So this was the parent judgment on this.
Definitely. It's clear as water. We don't have to even get into judgments, Miller, for a simple thing like this. The worst part is, Miller.
You have a photocopy of this.
I'll give you a lordship the book, Miller.
Book. Give
I'll
the
give you a
photocopy
lordship, I'll
of.
give you.
Yes. Anything more?
There is one more submission. which was the
Yes.
last submission. Then, my lord, there was one more submission which was made, which was a little weird, was that he is not in breach of the order in appeal, but may have been, my lord, in suit. Since the suit has gone, my lord, with a lot of respect to my learned senior friend, if he felt that he was on suit,
Perhaps that was not made, that case was not made out before the
Never.
appellate court.
I did not stop him, my lord, because Mr. Datta was making a submission. Never made out this case. Can never be, because the
Because
undertaking
there is
was
no
given-
written objection there too. Even if there is a written objection, they did not make that submission in that line before the appellate court. Anything more? Sir Datta, reply. How much time?
Abar ki?
Reply if he wants. He is the petition.
It's one judgment I have given. Not on facts, only on.
No, nothing on facts. First is, my lord, if the order passed, my lord, in a appeal is incorrect.
There is, I'm not multiplying, but this has also been referred to very recently, my lord, in 2023, 17 SCC 545.
1996 4 has been relied upon. 2023
17 SCC 545.
paragraph.
Paragraph, my lord, is, give me 1 second. That's it.
Party-wala judgment, undertaking which.
Correct. But after 96.
After paragraph 96.
It's a very long judgment. I guess I need not trouble your lordship with this. That's fine.
Yes.
Oh, 74 would be a little bit 74.
Paragraph 74.
এই 23-এ
হ্যাঁ, এটা দেখে নাও, এখানেই আছে। এই তো নরমাল, তাহলে আর কেন এত আর্গুমেন্ট?
That is the issue.
that whether, my lord, the court proceeded on the basis of the undertaking simpliciter or the court applied its mind and thought that no stay is required, no injunction is required. That is where your lordship has to decide whether I'm right or wrong. My lord, if I am right, then, my lord, that order is not required to be challenged. Even in a collateral proceeding, I can go and say that that particular order was passed in an appeal which was time-barred, therefore that has got no binding effect. So in a collateral proceeding also, if I can take, subject to correction by your lordship, but I can definitely, my lord, try to get rid of that order or the binding effect of that order, my lord, in this proceeding itself, without challenging, my lord, the order. But this would be my submission. And, my lord, কোথায়? ওখানে এখানের জন্য না। This is number one. And number two, these two judgments of 1996 and 2023, my lord, these are where, my lord, injunctions have been passed by court and violated, ignored by one of the parties. Ours is a case where the court says that I'm not going to pass an order of stay or a stay is not required. Therefore, please consider, my lord, whether the principles in these two judgments would apply or not.
The court says I will not pass an order of stay because of that undertaking. Because of that undertaking, not.
So, Mr. Dotto, your submission is that if there was an order of stay passed, in violation of that, you have taken possession.
Right.
Then, yes, the principles, the judgments which Mr. Chatterjee is relying upon may have some application. But in this case, stay was refused. So if there's a refusal of an order of stay, there is no question of violation of that order of stay.
Right.
So to put him back in the position. So that's
take a situation. The court had, my lord, coined the order in this terms that in view of the undertaking, there would be a stay of the order for XYZ period. Then, my lord, these judgments possibly would have applied.
That's exactly what the court has recorded.
But the court says the court does not depend on my undertaking. Court independently applies its mind, therefore 3 lakh to be paid. If it is paid, what is the consequence?
And even better.
Therefore, my lord, there is no order of injunction passed by the court.
So according to you, there is no violation of an order of injunction or stay.
Right. And the other thing, my lord, the first submission of my learned friend, my lord, I have taken instruction, my lord, it was attached, my lord, by the process server, I mean in the conspicuous place of the area on 6th of February 2026 at 17:15 hours.
Don't even look into this. This is John Proceedings. I don't have a right to even will challenge.
No, then he should give up this point.
Why?
Then he should give up this point.
Why should I? I have said that you have not taken this point in the court below.
No.
I am on that. I was not on facts.
Well, my
difference, Mr. Dotto.
Milord, if the date of publication is the starting point of limitation, as my learned friend has argued, rightly he has argued this point, the answer to it is that the publication was made on 6th of February 2026.
Yes.
Lord, a state should never act in this manner.
No, no, I'm not a state.
You are Article 12 state.
No, no, no. I'm
There's
not
a writ petition.
Anything more, Mr. Dotto?
No. Kindly, Milord, the factually this part only.
Yes.
That on 6th of February.
Yes.
কি হলো? তা এখানে কি অর্ডার আছে?
না না জজ সাহেব এখন দেবেন order.
My learned junior says that the matter is fixed in the court below on 3rd of September. Well, we can expect an order before that, whatever is the order.
I will try. That much I can tell you.
না না কেন অত ইয়ে করছিস? এখানে
আসুন।
hearing হয়ে গেছে।
Heard Mr. Dotto learned
But I don't think I am not inclined to Millard communicate it to the court. But Millard, in the last order, the court has recorded that the matter is fixed on 3rd of September. In the meantime, to produce directions from the Honorable High Court.
Yes, directions from the Honorable High Court.
in the meantime.
To bring directions from the Honorable High Court.
No, that was with regard to any stay of that order.
No, stay. Yes, stay of that.
Stay of that order.
They will proceed.
No, we have filed an application Millard, for police help
assistance.
that the court will have to hear. So that will never happen on the 3rd.
আরে ওখানে কি objection দিবি তো? তারও তো একটা objection দেওয়ার